The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court. The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
Chief, I'm sorry, before we get started, is Mike still there?
Yes, sir, I am.
Mike, I don't see myself up here on the screen. Is that
Yes, sir. When you're using the Polycom with Zoom, you won't see yourself.
Got it.
But
Okay.
I have you set up.
Great. Thank you.
Thank you.
Thank you. Now I get it.
All right. Ms. Saharia?
Good morning. Good morning.
Good morning, counsel. You may proceed when you're ready.
Thank you.
I'm sorry, the attorneys that are not arguing this case, please turn off your camera and mute your audio, please. Sorry about
Sir,
that.
Sir, I hate to interrupt. We have nothing but a black screen and we are not able to interact at all in terms of shutting off video or audio.
It's Mr. Hartnett.
This is Mr. Macbeth, Your Honor. I'm so sorry to interrupt.
Oh, yeah, you shouldn't be until the time, I think. Is that right, Mike?
They are actually connected to the conference. They should be able to see things. It may be something on their end. They should be able to see the other arguments.
We can't. We're going to try and connect with a different computer and see if that fixes things. I'm so very sorry.
Okay, when you get connected, just I'll bring you in, but immediately when you get in the conference, please mute your video and audio.
Yes, sir.
Thank you.
Thank you.
Shall I proceed?
Yeah. Yes, you may. Please. Go ahead, counsel.
Thank you. Good morning, and may it please the court. Amy Saharia of Williams and Connolly for Appellant Liberty Tax. This is not an appropriate case for relief under the high standard of Rule 59E. AIM alleged in his counterclaims in this very case that Liberty failed to pay rent on his properties. The parties went to trial on those allegations, at which AIM proved up his claimed damages. Due to his own lack of diligence, it turns out, he missed certain categories of his damages. Rule 59E is not intended to give litigants in these circumstances a second bite at the apple, and the district court abused its discretion in holding to the contrary. Now, I think there's two fundamental flaws in the court's ruling below, either one of which suffices for reversal. First, the court failed to take account of material factors relevant to whether AIM exercised diligence by focusing exclusively on whether he could have discovered the landlord proceedings and not the unpaid rent itself. And second, the court erroneously excluded the document showing that AIM was on notice of the landlord proceedings. If I may, let me start with the issue of diligence, because I think that's the easiest way for the court to resolve the appeal. The court failed to take account of material factors relevant to the inquiry of whether AIM could have discovered his claimed damages by exercising diligence. The newly discovered evidence in this case is the unpaid rent on the Burnside property, but the court simply failed to analyze whether AIM could have done something to discover that unpaid rent. It instead focused its analysis only on whether he was actually on notice of the landlord proceedings. And that exclusive focus on those proceedings caused the court to not consider the broad range of things that AIM could have done to discover the unpaid rent. First of all, AIM was undoubtedly on notice of the possibility that rent was not being paid at that property. That was, after all, his allegation in this case. It was also his allegation, which he made under penalty of perjury.
Ms. Saharia, excuse me, when you say that was his allegation in this case, you mean to say, I think, that he made a broad allegation regarding unpaid rents, not that he identified the Burnside property expressly as part of his claim. Is that right?
Correct. He made the allegation as to all of his properties. There were, I think, 8 or 9 properties, but he did not specifically tie that allegation in this case to the Burnside property. He just made it broadly
So
as to
that,
all
I
the
mean,
properties.
that by itself, I don't think would be enough, right? There has to be something more to suggest that he either knew or should have known that was part of the universe of the outstanding rent payments that were due on his property. So what is that?
Well, there's several things. First of all, there's the allegation that he made under penalty of perjury in the New York proceedings that Liberty had failed to pay rent on the Burnside property itself.
So can I ask you about that? So I know, the district court judge in this case made some rulings regarding the authenticity of certain documents in those New York proceedings, and he stuck to the black letter of the law that he believed required a certification from the clerk of court. But were there any subset of those documents that were admitted into the record without objection, so that and if so, can you point us to that subset of documents that actually shows actual notice?
The judge simply refused to consider all of those documents on the ground that they didn't have a certification attached to them. So he did not admit any of those documents as part of his consideration of this motion. No,
Not even the complaint in the state court? I thought.
Well, he did consider, of course, the landlord judgment itself, because AIM attached that to his motion. And he did consider the judgment. I don't recall whether he considered the complaint. He did not consider AIM's complaint, alleging that Liberty had failed to pay rent on the Burnside property. Now, but even putting aside the New York proceedings, of course, this case was about the rent. And there was also testimony at trial from AIM's former employees to the effect that Liberty was not paying rent at the properties. Generally, they did not specify which properties they were talking about. And then there was the fact that AIM himself acknowledged that Liberty was not paying rent on various properties because he paid the rent himself on some of the properties and then sought reimbursement from Liberty for that rent. Now, all of this should at least have put him on inquiry notice that he should do something to ascertain the status of the rent on the Burnside property, which was part of this case, after all. And he remained the lessor on that lease. Figuring out the status of the rent was as simple as picking up the phone and calling his landlord, which apparently he never did. He admitted at trial. Yes, Your Honor.
You say I just want to make sure I understand the context here. He has the burden to prove due diligence. And you keep saying what he did or didn't do. Did he put forward evidence proving, what he did or didn't do, that he didn't make that phone call?
He put forward no evidence, Your Honor, no evidence about what he did.
That's what I'm asking. When you say he apparently didn't make that call, like he had the burden to prove due diligence. I get the presumption here is that he either didn't make the call or he's lying about having, that he didn't know. But we actually have to have proof of that, right? Don't we?
Exactly, Your Honor. It is his burden to prove diligence. And all that he did was attach an affidavit or a declaration to his motion in which he stated he didn't know about the judgment against him. And that's it. That's all that's in the record about what he did. Nothing about whether he called the landlord, nothing about what he did in discovery in this case to try to prove his claims. These were his claims. He had the burden of proof to prove his damages. He didn't ask Liberty in interrogatories about unpaid rent. He didn't ask at depositions. He didn't ask at trial. He didn't serve requests for admissions. He didn't do any of that. All that he can point to, and I think this is actually quite important, is he points to a document request that asked about rent. And he says Liberty didn't produce any documents about rent. It is true that Liberty did not produce information showing rent payments during the period that is relevant to this motion, which was May 2016 and on. But Liberty was actually very candid at trial about why it had failed to produce that information. This is at JA 509 to 510. There's a colloquy between the court and Liberty about why Liberty had not produced any documents showing rent payments or other expenses after April of 2016, and Liberty explained that that was because it wasn't paying the expenses after April of 2016. So if that didn't put AIM on notice that he had a claim for rent at this property after April 2016, I don't know what would have put him on notice. And yet he didn't prove this at trial. He also points to an exhibit that was prepared and presented at trial as an agreed exhibit. Just to be clear, that is his exhibit. He prepared it, and it's a summary exhibit of his claimed rent damages. And the parties just stipulated to a number of exhibits that could be presented without objection at trial. But there's no representation in that exhibit from Liberty that that is the total universe of AIM's claim damages, nor would it even know what the total universe of AIM's claim damages was, because it wasn't possessing this property at the time and wouldn't know whether rent was still accumulating or whether there was, for instance, some other tenant in that property by that point in time. The simple fact is he just missed these damages in his calculation. He didn't do anything to discover them. And for that reason, and he failed to show that he, as Your Honor pointed out, he failed to show that he conducted any diligence. We think for this reason, the court need not even get into the question of hearsay and authenticity with respect to the New York documents, although I note that AIM has really failed to respond to those arguments. We think those documents clearly show that he was on notice of those proceedings. Under New York law, the affidavits of the process server are prima facie evidence of proper service, and it was incumbent on him to do something more than just a blanket denial to negate that prima facie case. But again, I think the court can easily resolve this appeal on the ground that he failed to show any due diligence to discover this category of his claim damages. If I may move, unless the court has further questions about that first aspect of our appeal, let me just very briefly address the issue of nominal damages. AIM concedes that the court should vacate the nominal damages award. Now, of course, he concedes that because he wants $1 million on that count and not $5,000 on that count, but it was incumbent on him to offer arguments to the court in opposition to our request to vacate the $5,000 award, and he's offered no such arguments, so we view that issue as waived. With respect to the cross appeal, I want to address for now just one issue relevant to AIM's cross appeal. And we think the cross appeal is clearly barred for all of the reasons that we set forth in our brief. The one issue I want to address is AIM's suggestion that somehow Liberty failed to appeal some aspect of the district court's ruling on the first go around. We think that's simply wrong. If you look at the district court's initial ruling after the bench trial, there's nothing in that ruling suggesting that the district court was awarding some separate theory of profits on count 2 of AIM's counterclaim. There's just no suggestion of that in the court's ruling, nor would that have even been proper. The party's contract clearly governs AIM's entitlement to profits. Section 4 of the contract provides that he's entitled to disgorge Liberty's profits only if his e-funds were reinstated by May 8th, 2016. Of course, we know that didn't happen. And so that's why the entire issue of profits, both at trial and then on appeal, on the first appeal, was entirely tied to whether that e-fund deadline had been extended. This court, of course, held that it had not been extended, and that just extinguishes his claim to any profits under the party's contract. And it's black letter law that the covenant of good faith and fair dealing cannot be used to displace the contractual terms in a contract. That's why the district court did not use the covenant to come up with some other theory of profits that would have been inappropriate. There was nothing for Liberty to appeal, and so that argument is just wrong. Unless the court has any further questions at this point in time, I'll reserve the remaining arguments for rebuttal.
Thank you, Ms. Sahara. Mr. Hartnett.
Yes, thank you, Your Honor. And may it please the court, David Hartnett on behalf of Greg AIM and his company, Wolf Ventures. As Ms. Sahara just announced, this is the second time we're here. And in the first appeal, in our opening brief, we pointed out that Liberty, in fact, was not appealing judgment on count 2 of our counterclaim, which was for breach of the implied covenant of good faith and fair dealing. And Liberty responded by saying it appealed count 2, but only insofar as it rested on the extension of the buyback deadline. And the reason that's so important here is that count 2 did not rest on the extension. It was based on a breach that the district court found as fact occurred long before the original May deadline. Its explicit finding of fact was that since inception of the PSA, Liberty never had any intention of selling these stores back to AIM, regardless of what he did. And it's undisputed that this aspect of the judgment was affirmed. If you look at the district court's remand order, he in fact says all aspects.
Counsel?
Yes.
Can I stop you? Because unless I'm mistaken, I believe Judge Diaz has left us.
Oh, I'm sorry.
Mike?
Yeah, Judge Diaz has dropped off. Stand by. I'm going to try to get him back.
Sorry to interrupt you, but just get.
Thank you for pointing that out.
That's less power. Judge Diaz?
Yes.
Yeah, you're back, sir. You dropped off, but I just reconnected you.
Thank you very much.
Thank you. Judge Diaz, I'm not sure at what point you dropped off. Didn't know how far back I should go.
You were talking about the fact that the concern about the breach of the covenant of good faith and fair dealing survived the first appeal. So you can go on from there.
Thank you. And as I was saying, that the district court in fact said in one of its remand orders that all aspects of the judgment were affirmed, except of course for the fact that the extension offer lacked consideration. And so on remand, when this court said to enter appropriate damages, that left only one question: what were the appropriate damages under count 2 of our counterclaim, since count 2 did not rest on the extension? And the answer to that question turns on an issue of law that this court can decide. And that is, does Virginia law recognize disgorgement as a remedy for breach of contract?
Counsel, I'm sorry. Just to make, maybe I wasn't following. I thought the question, at least one of the two questions, was what were the damages on count 1? And that's the $250,000 that y'all ultimately agreed upon, right? That was one of the questions. You think there was also a second question?
Right, you're exactly correct. For this appeal, the remaining questions count 2, because you're right, count 1, the party stipulated to what those remaining damages would be.
And those are the contractual damages. You're arguing under count 2 that you were entitled to extra contractual damages, tort style damages.
No, we're not asking for extra contractual damages. We're saying that the $250,000 compensatory damages were for count 1, where we alleged failure to pay rent and utilities and failure to reimburse AIM for expenses that he paid. That's what count 1 was for. Count 2 is for breach of the implied covenant of good faith and fair dealing, which the court found Liberty breached by never intending to honor its obligation to sell the stores back. But it's not extra contractual. This is still based on that breach.
So you agree that count 2 is limited to contractual damages?
And that's the argument here. And so that's the question. When the district court on remand, it said, the district court said its reading of Virginia contract law is that I can't do disgorgement because that's an equitable remedy, which I can't do on breach of contract. And that is where the district court erred, because this court and the Virginia Supreme Court have both said that a plaintiff may be entitled to disgorgement as equitable relief for breach of contract.
Mr. Hartnett, can you hear me? So just to follow up on Judge Richardson's question, so the parties agreed on the contract damages on count 1, and the court in the first case, I know you disagree with this, and I respect that, found that there was no consideration for the extension of the deadline to get the EFIN, right? So, but it was during that period of time, wasn't it, that your client or that Liberty garnered the profits which you are now trying to disgorge. So it's not clear to me how you can allege a breach of the covenant of good faith and fair dealing based on an extension of a contract that we found to be invalid for lack of consideration.
Right. The mandate from this court, as you're correct, said that AIM was not entitled to the lost profits that he would have earned based on the extension of the buyback. If the extension was valid, then he would have been able to earn those profits from that tax season and lost future profits. Here we're saying that even though, and we're not disputing that, it is the law of the case. We're asking for what damages are left from before the extension. And we're saying as an alternative remedy, but still under contract law, Liberty, the only way it was able to earn those profits in the 2016 tax season was through its deliberate and willful breach of the implied covenant of good faith and fair dealing. And the court.
But the breach was the failure to honor the extension, which the court found lacked consideration.
I respectfully disagree, Your Honor. The district court said that the evidence that proved breach of the implied covenant was that since inception of the PSA, Liberty was never going to honor its obligation. The evidence was that right after the PSA was signed in January, Liberty immediately turned around and was preparing to sell the stores to somebody else. And it came very close to doing that before the original deadline and before even the extension of the deadline was even brought up. And so the court said, if you were going to sell those stores from the get-go, you obviously were not intending to honor that. And then later on at trial, when we presented evidence that Mr. AIM did get his EFIN before the extended deadline, he got it in September, we said that's ahead of the December deadline. Liberty's defense at trial was not that, no, the extension's invalid for lack of consideration. Its defense was that it doesn't matter if he got it or not, because under that paragraph 4 of the PSA, it's still subject to our discretion whether or not we have to give all the stores back. And the district court honed in on that and said, your treatment here, you're saying that even if he gets his EFIN, you still don't have to sell the stores back. You're going to say he doesn't qualify for our standard sales and approval process. The district court said, finding in fact that course of conduct, both before and after, demonstrated that it was never going to honor it, meaning that it made no difference if AIM got his EFIN before the deadline.
But Mr. Hartnett, how does that course of conduct equate to disgorgement damages? I mean, they could say all manner of terrible things about their unwillingness to honor the contract, but the fact remains that after the deadline, the initial deadline expired, they had no obligation to honor the contract because there was no contract.
Right, and the district court's finding was that it made no difference of when or if Mr. AIM got his EFIN. Liberty was never going to honor that regardless. And the Fourth Circuit and the Virginia Supreme Court said that in a breach situation like that, where it's deliberate, the focus is on the violator's wrongful conduct. It's not on what the
Never
plaintiff did.
That doesn't make sense, because the yes, whatever the intent was may have pre-existed May. The district court's finding was that the breach of that was in September, right? When he actually had the EFIN. There was nothing to breach, right? An applied covenant of good faith and fair dealing, they couldn't breach that until September when he had his EFIN. So I think Judge Diaz's point, I take it, not to try to co-opt it, is that whatever the intent was at the earliest moment, the covenant was not effectively breached to cause any harm. Maybe it's a causation problem until September. And as we now know, the September, there was no contract.
Understood. I appreciate that. Again, the district court said they breached on right after the PSA was signed. That was the finding. And the point that I want to raise is that think of it almost as an anticipatory. I'm sorry.
But that doesn't make any sense, right? You can't breach before a point in time. That if the district court said that, I don't understand how that makes sense. It seems to me what the district court intends there is that the intent was at that time, but it wasn't a breach until September, because there was no obligation to do anything until September.
The analogy that I have is think of it in the context of anticipatory repudiation. Say in February or March, Liberty had come to AIM and said, we know we were going to give you till May 8th, but just letting you know, we're not going to honor that contract. At that point in time, if Liberty had come to AIM, he could have sued right then before the time for his performance came and could have sued for damages. He would not have had to show that he could perform. The fact that they made that repudiation ahead of time would have excused that. The only difference between that
But
situation
with the
and here-
damages, Mr. Hartnett, in that scenario, would they have been the actual lost profits? Because at that point, we don't know what the profits are. If you're saying that that was a total breach, end of the contract, you get whatever damages you might be entitled to then, but you certainly wouldn't be entitled to any lost profits because none would have existed at that point in time.
Right, which is why we've confined our damages here for pre-extension breach, the profits that they earned before the deadline during the 2016 tax season, not after.
And that equates to how much?
Just as in, it was stipulated at trial, the 1.7 million. Both parties agreed that is what Liberty made from profiting from that breach. There's an agreed exhibit on the amount of I'm rounding up, but it was 1.6 something million. And again, the case that I think is key here from this court from 1990 is Eden Hannon versus Sumitomo Trust and Banking. That was at 914 F second 556. And the reason I want to spend time on that is because I think it controls here. In that case, the defendant signed a non-disclosure agreement, but then it used the plaintiff's confidential information to outbid it on a contract. The defendant was the first place bidder using that information. Another party, a third party, came in second place, and the plaintiff was the third place bidder. The plaintiff sued for breach of contract. The district court issued an injunction, but said it couldn't award any money damages because the plaintiff couldn't show any injury. They said, you came in third place. If the defendant hadn't done that, second place guy would have won instead. But this court, citing Virginia Supreme Court law, reversed and said, no, that we can still impose a constructive trust on the profits that the defendant gained. They said, because equitable remedies are available for breach of contract. They said that the remedy didn't depend on whether or not there was actual damage to the plaintiff in that case. It said to focus on the wrongful conduct of the violator, as I mentioned earlier. And importantly, the court in that case, it acknowledged, it says, yes, we know that the plaintiff cannot establish it would have won the bid, but it doesn't matter because we can determine what the defendant's profits were from its breach. Just like in our case, as I alluded to a second ago, we know exactly what the amount of Liberty's profits were from its breach because that was a stipulated amount at trial. And so, of course, that court imposed a constructive trust on profits when a plaintiff couldn't show damages. Constructive trust on profits is the same thing as disgorgement. That's what we're asking for here. And so if you apply that holding, AIM is entitled to disgorgement of the profits that Liberty made from its breach. Again, the focus is on the wrongful conduct of Liberty. And it's important because, again, the district court reiterated on remand that the reason Liberty didn't sell the stores back was not lack of consideration. It was because since the inception of the PSA, Liberty was never going to sell the stores back. That's the part I think is really worth emphasizing here. And with that, I was going to save the remaining time for rebuttal. As far as Liberty's cross appeal, unless the court asks questions specifically for me, we intend to submit it on the papers because we do believe the district court's analysis was correct. There was more than enough information.
Mr. Harden, may I ask, sorry, something came to mind here that I hadn't thought about. So as I listened to you, your argument appears to have some facial appeal, but the problem is, now that I remember, is that none of these arguments were presented during the first trial with respect to equitable relief. So one of the responses that I'm sure you're going to get from your friend on the other side is, this is too little too late. What's your response to that?
We asked for these damages initially in our counterclaim, and then again, disgorgement did not become relevant until remand. We already had a judgment in place on count 2 for the profits that Liberty Tax earned. And it was only on remand that we had to decide whether or not we could still get those damages. And disgorgement is a valid remedy, and Rule 54 allows the court to include that. Whether or not we asked for it in the counterclaim or earlier, it's still a valid way to get to that damages. I don't know if that was clear enough, but Rule 54 is what allows us to do that. Okay. As I was saying, for the Liberty's cross appeal, we believe the district court's analysis was entirely correct. We don't believe there's any abuse of discretion here. The only other things I wanted to point out that were raised a moment ago during oral argument, Liberty tries to gloss over the fact that there was an agreed exhibit as to unpaid damages. Again, think about that. AIM says, yes, to our knowledge, this is all the unpaid rent that's out there. And as we're making that representation, Liberty says, yes, that's the agreed amount. subject to Rule 11, we're making that representation to the court. It was receiving notices from the landlord that in fact was not true. There was additional unpaid rent, and it never told AIM about that. There's also evidence on the record that, yes, we asked for it in discovery. We had a motion to compel, but also AIM had paid
Mr. Hartnett,
rent.
you seem to be arguing that Liberty was required to make its case for you and your client. That's not true. That's not correct.
Well, I'm saying, like, when we say, is this the correct amount of unpaid rent? And they know for a fact that there's additional unpaid rent out there. They have an obligation, especially when we ask for proof of payment and proof of rent in discovery, they have an obligation both ways to come clean with that. And furthermore,
How did you phrase so tell me again, how did you phrase the question?
In the discovery question?
Yes.
If you allow me on the 5 minutes of rebuttal, I will track that down and get the answer for you.
Okay.
And again, just think of the context. At the time this rent is not being paid, AIM is suing Liberty for unpaid rent. It is inconceivable that he would have had this knowledge and just sat on it. That's the last thing I'd like to say.
Thank you, Mr. Hartman. Ms. Sahari?
Yes, briefly with respect to our appeal, I just want to clarify one thing for the record. The allegation from counsel that Liberty was receiving notices of the unpaid rent and knew about it appears to be based entirely on the fact that the landlord had attached notices on the door of the property. But counsel conceded at trial that Liberty was no longer occupying that premises after June of 2016. So I don't think that's a fair assumption to draw from the record. AIM was the lessor. He was the one receiving the legal notices from the landlord. And for all the reasons I said before, he did nothing to show any diligence on his part to discover his claimed damages. With respect to AIM's cross appeal, a few points. I didn't hear any response from counsel on the fact that Section 4 of the parties' contract explicitly governs AIM's entitlement to profits. I didn't hear any response to the point that the covenant of good faith and fair dealing cannot be used to rewrite the terms of a party's contract. And Section 4 of the party's contract entitles him to profits only if he restored that EFIN by May.
But counsel implied covenant of good faith doesn't have to rewrite. The writing is in one's honor. It comes from the honor in the sense that you make an agreement, you have an obligation not to do anything that's inconsistent with accomplishing that. Why do you have to rewrite the ethos of contract under our law in our country?
Well, the parties' contract provided that Liberty would be required to pay profits back to AIM if he restored his EFIN by May 8th and bought back the business. He didn't do that, but nonetheless, he wants this court to give him all of Liberty's profits that it was earning during that time, even though the condition precedent for him to obtain profits, he did not achieve. And so that's what I mean by rewriting the contract. What he wants the court to do is to say there was some breach of an implied duty, and I'm therefore entitled to damages that the contract forecloses.
You know, the allegation is that your client never intended to do the right thing ever. That's what he's saying. You never did. That this was just a ruse. That you had no good faith when you signed the PSA. That's what his allegation is. Not about May going by without him getting his certification. It's about you, as he's alleged, an equitable remedy he's saying is that you were dishonest with him, not you, your client. That's
understood, Your Honor.
That's his allegation. So why is that temporal to May, when that's the whole theory of implied covenant of good faith? If it exists, when does good faith start? An obligation to have good faith?
Well, of course, it starts once the contract is in place, Your Honor. But to the extent he's claiming that Liberty never intended to abide by the PSA, that fraud claim has been dismissed and was affirmed by this court. And to the extent the claim is there's some other breach of the contract, some lack of intent to comply with it by selling back the business to AIM. Intent to breach a contract is not a breach of contract, and the breach could not occur until he restored his EFINs and therefore had an entitlement to buy back the business. And
Ms.
that
Zaharia,
just never happened.
Your colleague on the other side made a point about the doctrine of anticipatory repudiation, and he argued that although that in this case, and piggybacking on Judge Gregory's point, your client made clear either from the get-go or shortly after the contract was agreed upon that they were not going to comply. And I suppose there's an argument to be made if that's true, then that's a total breach of the contract. At that point, he's entitled to sue for his damages, and he alleges that the damages were the profits that were, that were garnered during the time before the extension was talked about. So, can you talk about that?
Yeah. So the district court addressed that argument in its first ruling on remand, and what the district court explained is that to award profits at that point in time would be completely speculative, even for the pre-May 8th period, because at that point in time, it was completely speculative whether AIM would have restored his EFINs and therefore entitle him to buy back the business. So even assuming AIM had filed suit, let's say in February of 2016, his lost profits would not have been an appropriate remedy at that point in time because they were speculative as to whether he would, in fact, comply with the condition precedent to get profits. So perhaps at that point in time, what he could have done would be to rescind the contract and put the parties back to where they were. But of course, that's not what happened in this case.
I'm sorry, go ahead, finish your answer.
No, well, I want to just make a few other points with respect to this issue.
No, I thought you were finishing your answer. I have a question.
Yes, Your Honor.
The other points. But the whole idea of the arrangement was to help him or help the company get along while they were in this limbo of not having the certification. And you were a caretaker, if you will. This was really, wasn't it the whole idea you would keep this going and then hopefully would get to the point where he could do this and you would give those things back. So even if he got to a point when he never got it, isn't the theory of it that you would still give him those profits? What would it make? They didn't belong to you, really. Wasn't it the idea?
I respectfully disagree with that.
Well, go ahead.
This was not a bailment contract. This was not some kind of caretaker contract. This was a sale. The PSA stands for Purchase and Sale Agreement.
I understand that.
AIM sold his business to Liberty. There was a condition precedent in the contract for him to buy back the business, subject, by the way, to Liberty's sales and approval process. And that condition precedent was that he restore his EFINs by May 8th, which he failed to do. And I just think it would be a gross
kind of the buyback based on? What were the payments? What was the money coming from for the buy? Did the profits have anything to do with the purchase money?
Well, if AIM bought back the business, yes. Yeah. If he bought, sorry, Your Honor.
Did the profits have anything to do with the substance of the purchase money?
No, Your Honor, except that if he bought back the business under Section 4, then he would be entitled to have Liberty's profits returned to him, subject to some exclusions during the period, the January to May period. But his ability to obtain those profits under the contract was expressly conditioned on his restoring his EFIN by May 8th. I think it would be a kind of a perversion of equity to give him profits that he is simply not entitled to under the contract. And he has cited no case from Virginia or the Fourth Circuit that awards a disgorgement style. Yes, Your Honor. I see your hand raised.
Chief, can I?
Yeah, sure.
Just ask the question. So he says, this is where I wanted to get you to at some point. He says there's this Fourth Circuit case, the three bidders on a contract case, that supports his conclusion that disgorgement is a remedy for breach of contract. When I heard the argument at first that disgorgement was a remedy for breach of contract, I felt my contract professor roll over in his grave. Like, so help me understand. That was a surprising theory to me. Why is that case, which I've read and I'm sure you have? Why do you say that it doesn't support his argument and it doesn't tell us that Virginia sort of novelly permits disgorgement of profits as a remedy for a breach of contract?
Sure. So he is the principal case that he relies on is the Eden Hannon case, which is a case of this court, and that case limits its holding to cases of non-competes, and non-competes are a special kind of contract where obviously one party agrees not to compete with the other, and in that particular circumstance, because the damages can be difficult to ascertain in that circumstance, courts have imposed constructive trusts on the parties who breach a non-compete. But the court was clearly talking squarely about non-compete contracts when it was talking about disgorgement as a possible remedy. He has cited no other case from Virginia or from this court involving disgorgement as a remedy for contract. He cites 2 law review articles in his brief. If you look at those articles, they make very clear that this is a novel theory of contract damages. And I think it would be inappropriate for this court to adopt such a novel theory of contract damages without any indication from the Virginia courts that it would do so, particularly when he didn't raise this theory of damages. He didn't raise it at trial. He didn't raise it on appeal. He didn't even raise it on remand. He raised it for the first time in a Rule 59E motion for reconsideration. And it is black letter law that motions for reconsideration are not vehicles for raising new novel theories of liability or damages in this case that a party never raised at any point before then.
But counsel, isn't your response to Judge Richardson the very reason why maybe it should be? This is unique, although this is not a non-compete. This is a case where it's very difficult to deal with disgorgement. There's sort of a situation where 2 companies are sort of working together in this formation of this PSA where they're operating, and then the profits, if you do what you're going to do, say you get these profits back. Because under your theory, you need some equitable way to deal with, because he would have their company would have no chance of any kind of breach as long as you could say, well, you never got your ethos back. You never got your authority back. So you can't do anything. So there are no damages ever, because they would never arise until you get that. And but that's the question. Almost like seems more like maybe unjust enrichment more than disgorgement, perhaps, in terms of equitable remedy that's parallel to a contract, that you were unjustly enriched because he claims that you never intended to do anything but to keep these profits from him. That's his whole theory, and that's the whole idea. It's very difficult to disgorge it, because you would say at the very end, well, you never got it, so whatever we did to you during the process, you have no remedy. If we breach, there's no remedy because you never got that back, and that's the whole point. It seemed to me that PSA was intended, that everybody was hoping and intending that he would get that. I mean, isn't it there? That's why, isn't it like the case that he cites, the Fourth Circuit, disgorgement, it was appropriate there because it's hard to figure it out, as you explained.
Yeah, I respectfully disagree, Your Honor, for several reasons.
You disagree with your explanation of Judge Richardson, the same parallel for why you're explaining away why that's an off case and should only be held to those narrow circumstances. Don't you look at the reason behind it, and the reasons you gave seem to me parallel here. It's difficult to determine what the profits will be. It's difficult to determine how far in, because the whole theory is that the case is that you never intended to do the right thing. You never had a heart of honesty at all. That's his whole theory.
That is his theory, but Section 4 of the party's contract, it is the contract. He agreed to Section 4 of the party's contract, and Section 4 does not allow him to obtain profits unless he restored his e-fence, which he didn't do. So unjust enrichment, crystal clear, can't be used to override a party's contract, and that's not the claim we have here. He didn't bring an unjust enrichment claim. breach of the covenant of good faith and fair dealing cannot be used to override the party's contract. It's not even its own claim under Virginia law, but even if it was, it can't be used to override a party's contract.
Mr. Haria, can I
Yes.
ask a question and perhaps make a statement? So this is piggybacking to what Judge Richardson talked about earlier, I think, when discussing this case with your colleague. If your client had done nothing, said nothing about its intent, and I realize that you dispute whether or not there was an intent to just treat this as a worthless piece of paper, the contract, as the district court judge seemed to suggest. But if it had done nothing and simply waited for Ames to perform or not, I don't think there'd be any question about the entitlement to any equitable relief. So I guess it strikes me that there's an issue of causation here, and whether or not, as you pointed out, the fraud claim in this case was dismissed the first go around. The district court judge in this most recent opinion seems to have had a little bit of buyer's remorse and seems to be suggesting now that he wished he might have stated more expressly that your client never intended to honor the contract. That may make out a fraud in the inducement claim, but that was not what the findings were below the first time around. And now we're relitigating issues that have been litigated and resolved. And so I just get back to the point. I mean, irrespective of what your client may have done or said, the fact of the matter remains that Mr. Ames didn't comply with the requirements of the extension. And it just seems like we're trying to fit a square peg into a round hole, and it just doesn't seem to fit. But anyway, that's not a question, it's more of a statement.
I'll just say I agree with that statement, Your Honor. We're here, frankly, because Ames is not satisfied with this court's prior ruling. Frankly, the district judge, expressed his dissatisfaction with this court's prior ruling, but it is the law of the case. He didn't restore his EFIN, and the parties did not extend the deadline for doing so. And to award him profits that he clearly is not entitled to under the party's contract, I don't think is a fair, equitable remedy in this case. Thank you, Your Honors.
Thank you, counsel. Mr. Hartnett, you have a rebuttal time.
Yes, thank you, Your Honor. Just as to Liberty's appeal, Judge Diaz, I have a paraphrase of our discovery request that's found on JA 491 to 92, where we asked Liberty to produce all documents regarding rent at the stores. 2016, that was the allegation. But getting back to
would that request, counsel, include non-payment of rent? I mean, the point is, as I understand it, they gave you the documents where they were paying rent. If you asked for all documents about rent, they gave you the ones where they paid the rent. But to ask for non-payment seems like the inverse of what you were asking for.
They did not give a complete production, and that's why we filed a motion to compel. The district court never heard that motion.
Right, but they also didn't file, for example, they didn't give you documents related to, payments of rent here in Columbia, South Carolina, right? Because they're not paying any rent in Columbia, South Carolina, I presume. So like the non-pay, to prove a negative, when you ask a document request, you don't get a listing of, and these are the things we're not doing. You get the list of the things that they've done.
Right, and we didn't get an answer either way on that. Again, under the PSA, Liberty was solely responsible after January 21st, 2016 for paying rent at all of these stores. After January 2016, Liberty was the only party in possession of these stores. The evidence is that Liberty had banned Mr. Ames from entering the stores for any reason. Liberty was in possession of the store when these notices were being posted at the storefront. We think that the idea is that evidence related to rent, that would have been responsive to that and related requests. Not just what rent are you paying, but if you're getting a notice from a landlord not paying rent, we feel like you have an obligation to come forward with that as well.
And so your theory here turns on the assumption that Liberty Corporate got the notice off the door and then refused to turn it over to you.
That's correct. Again, Liberty was the only one in possession. It had the only obligation to pay this rent, and it never notified him that it wasn't being paid. And again, this is at the time where we're suing him for unpaid rent. Liberty's appeal is suggesting that we somehow received this notice and sat on it when that, as the district court said, that makes no logical sense at all.
Can you talk a little bit about what evidence you put in of your due diligence other than at least allegedly this one document request? So I understand you said, I didn't know about it, and I don't mean from your perspective, but your client didn't know about it. But what evidence, where can I find in the record evidence that you put in of your due diligence, where you did anything affirmative to find this information?
Right. And again, it assumes that we had an affirmative obligation when in fact, under the PSA, it was Liberty's obligation to pay rent and to indemnify AIM for any liability
Accept
arising.
my assumption and go to the question instead of fighting the question. And the question is, what evidence did you put in to show that you engaged in due diligence?
Again,
and fine. I just want to make sure I've looked at everything in the record.
Right. Again, the evidence is that Liberty is paying the rent, and AIM did not receive a notice from either Liberty or the landlord that rent was not being paid. So the due diligence, he had no reason to question whether or not rent was being paid at that store. It had been paying on that store throughout. All of a sudden it stopped paying, but no one told him. So why would he have any obligation to contact the landlord just to confirm payments were being made as before? It's almost like there needed to be something that triggered him to have to act on this. And there was never anything until he discovered after the fact that the judgment had been imposed against him.
Mr. Harder, can you tell me very succinctly and hopefully briefly, what exactly would you say the evidence that you have that Liberty never intended to fulfill its obligation in its contract?
Right. Liberty manifested that the very same day it signed the PSA. As soon as Mr. AIM had signed the PSA, Liberty had another person submit an application to purchase those stores. The district court finding of fact lay out all the steps that were involved. He had to go through, he had to get his own EFIN, he had to pass audits, he had to do several other things, and Liberty was checking the box. And even in March, as they were preparing to sell these stores, they said, understand that if we sell the stores to you, we are not going to let Mr. AIM buy these stores regardless of his EFIN status. That is in a written email to this purchaser. So they
were dealing with third parties in a way that clearly was contrary to the intent and the mutual promises of this contract, correct?
Correct.
Okay, go ahead. Anything else?
No, again, counsel brought up the fact that it'd be a perversion of equity for AIM to have this money. But in fact, the district court said that Liberty was the one that displayed bad faith throughout. And he took the time to point out that Mr. AIM acted in good faith throughout, that he did nothing wrong, and that the only reason he didn't finally get his EFIN was due to circumstances beyond his control. So the idea that perversion of equity would work against Liberty is simply wrong.
You have anything else further? You have,
no, Your Honor.
You finished? All right. Thank you, counsel, very much. To both of you, we regret that we cannot fulfill our normal tradition of shaking hands, but even though we're in this virtual setting, please know that the spirit is the same, and we appreciate so much your argument. And thank you so much, and be safe and stay well. Thank you very much.
Thank you, Your Honor. You too.
All right.
Thank you all.
All right, bye-bye.
When they refused to recognize that Mr. Noru automatically became an asylee when his mother was granted asylum by the immigration court. I'm sorry, Your Honor?
I didn't say anything.
Oh, okay. The answer to this question rests purely in matters of law and how to interpret two regulations, 8 CFR 208.14 and 8 CFR 208.24. and also a recognition that these two regulations complement each other. Each of these regulations is tasked with two separate tasks. The first, 208.14, has two main tasks. The first of these is deciding which agency has the authority to adjudicate asylum claims. The second task of 208.14 is deciding what options the agency has available to it for adjudication. 208.14a describes the answer to these questions as it relates to the immigration court. It simply states that the judge may grant or deny cases they have jurisdiction over. The court may only grant or deny asylum applications. Those are its only two options. Sections 208.14b and c concern the authority of the asylum office to make decisions and also specifies the options available to the asylum office for adjudication. 208.14b simply states that the asylum office may grant asylum. 208.14c states that if the asylum office does not grant, then they must deny, dismiss, or refer the application to the immigration court. The second regulation at issue here is 8 CFR 28.24. Point 24a is concerned with the termination of asylum that was granted by the asylum office only. It has no effect on the termination decisions that are made by the immigration court or any other agencies. 8 CFR 208.24e states that when an alien's status is terminated under this section, then the service shall initiate removal proceedings as appropriate. So the only real issue before the court today is to determine whether 208.24a and e make section 208.14 superfluous, as argued by the respondent. Our position, of course, is that the two regulations are complementary. 208.14b and c applies as long as the case is in the jurisdiction of the asylum office, and as long as the case is in the jurisdiction of the asylum office cannot bypass and ignore 208.14. So this argument of the respondent that 208.14 of the petitioner, excuse me, I'm used to saying respondent from immigration court. The argument of the petitioner that 208.14b and c remains applicable, even when 208.24 is at play, is supported by section 208.2a. This regulation states that the asylum office, through the Refugee Asylum and International Operations Office, shall have initial jurisdiction over asylum claims. 208.2b states that the immigration court has jurisdiction over asylum claims upon the filing of the charging document, such as the notice to appear that was filed with the court on August 14th of 2013 in these proceedings. It is upon that filing of that charging document that the jurisdiction over adjudication of this case exchanged from the asylum office to the immigration court. Simply put, the authority of the case lied solely with the USCIS until the NTA was filed with the court. On August 14th of 2013, when Mr. Noro was 21 years old, the asylum office terminated his mom's asylum and filed their charging document with the court. Then as a result, they exchanged their jurisdiction to the immigration court. 208.24 does apply to this case. It is very important in how this case proceeded, but it simply states how asylum is terminated, the procedures that the asylum office uses in determining whether to terminate asylum. And if appropriate, it also mentions that removal proceedings must begin when asylum is terminated.
Mr. Roberts, can I ask a question? So you just indicated as you were talking through these regulations that the USCIS office terminated the original asylum application. I mean, but doesn't that essentially make the government's point if that asylum application was terminated and the rights thereunder were extinguished? Don't we have a new case now being pursued in the immigration court, and that new case necessarily requires consideration of new facts? And one of the unfortunate new facts of this case is that your client is no longer a minor. And doesn't that end this case?
Uh, Your Honor, I don't believe it does. And I think this is one of the fundamental misunderstandings that I believe was the problem throughout the process.
So what does it mean? I'm sorry. What does it mean to terminate the asylum? What do you think that means in terms of the consequence for the subsequent proceedings in the immigration court?
Well, there are lots of things that I think about that question, Your Honor. The first has to do with what I was talking about with 208.2. I think 208.2 is extremely important for this question. And the reason for that is it talks about the jurisdiction of the asylum office. So why this is important is that when the asylum office has jurisdiction, they can approve it. While they continue to have jurisdiction, they can terminate it. So this intermediary step of approval and then termination doesn't change the fact that at the conclusion of their jurisdiction, they did not grant asylum. Since they did not grant asylum at their conclusion of their jurisdiction, then the case should have been referred. It is not a new application because at the end of the jurisdiction, asylum was not granted. The fact that it was granted as an intermediate step only confuses the issue. Regarding the
I'm not sure what you mean that it's granted as an intermediate step. It either was granted or not, and the government says it was granted at that initial step and then subsequently terminated because of the allegations regarding fraud, which the immigration judge, to his credit, at least engaged with and determined that your client was not at fault. But the fact of the matter remains that that initial application was granted, the asylum application was granted, it was terminated, and from the government's perspective, we're now dealing with a new claim, and the sad fact that your client is now an adult, no longer a minor, and therefore no longer entitled to derivative asylee status. So I don't know what you mean by terminated as an intermediary step. What does that mean as in the context of the regulations?
I think it has to do with the meaning of this phrase you used, as an initial step they were granted. As an initial step, she was granted asylum. As an initial step, that asylum was terminated. They're both initial steps under the regulation. They're both initial steps under the regulation because...
What else would have had to have occurred in order to make that final, in your view?
The loss of jurisdiction. It becomes final upon the loss of jurisdiction. The jurisdiction is lost according to 208.2b when the NTA is filed. Until the NTA is filed, it's always going to be an initial step, as 208.14 states. It's the initial authority.
Sorry, Mr. Roberts, let me make sure I understand. But asylum is always, I guess, contingent. It's never permanent. I don't think you can lose the benefit of asylum either because of change in conditions in your home with regard to the petitioner. So in that sense, I guess you're right that it's never final, but I don't know that it answers the question as to the fact that the USCIS terminated that determination of asylum, and then a new case began anew in the immigration court. And I'm still struggling to understand why that new case doesn't now require consideration of new facts.
Because, Your Honor, I do not believe it is a new case. I think the arguments that this is a new application is a circular argument. They're saying it's a new application because it's not referred. Because it's not referred, then they say he's not protected by the Child Status Protection Act because he's over 21 and he needs his own application. In our opinion, this is not a separate argument. It's the same argument we've been discussing. If a case is referred, then the judge adjudicates the referred application. If it's not referred, the IJ adjudicates the new application. If the court determines it's a referred application, which I'm arguing that it is, then his mother's adjudicated asylum application was in fact the original one, and the petitioner is protected by the CSPA. Because the case was referred by an active regulation, it's not a new application. The regulations, in fact, allow an application to be amended and supplemented. The immigration judge having jurisdiction may permit an asylum applicant to amend and supplement under 8 CFR 208.4C. When additional grounds were added to the asylum claim, in fact, it was being amended and supplemented. It's not a new application. Again, the reason that I say that it's not a new application is because it is referred. When an application is referred, it is sent to the asylum office, to the court as part of a referral package in compliance with 208.14B and C.
Mr. Roberts, I'm sorry. Go ahead, Chief. Go ahead.
No, go ahead. No, go ahead. Your line. Go ahead.
Thank you. Where in the record is the evidence that, or the finding, or whatever it is, the document that says this case has been referred from USCIS to the immigration court? Where is that in the record?
Well, to the contrary, Your Honor, I think if you look at if you look at the pages 74 and 75 of the certified administrative record, it says to the opposite, that there was, it makes it clear that there is no referral package. And again, but this is a circular argument that I was referring to. They're saying that this is not a referral because there's no referral package. But this is the point that I was trying to make. It's not the referral package that makes it a referral. It's the application of the regulations that make it a referral.
Okay.
Well, Mr. Roberts, it was referred from the government standpoint, as they've said, for the purposes of removal, to give due process for removal, correct? Why do you think that? Why do you seem to concede that DHS has the authority to terminate asylum? Why do you concede that?
They have the authority to terminate asylum because 208.24 gives them that authority.
Yeah, but you started the movie too late. You got to start the movie from the beginning. The beginning is the United States Congress. Congress acted in the Immigration and Nationality Act. That's where the authority comes from. It's Section 1158. You have to first deal with that. And in that authority, it gave the DOJ the right to grant and to terminate asylum, but it did not do so for DHS. It did not. And when it amended that act in 2005, it specifically did not give them that right to terminate asylum. The referral is for removal, but the asylum is not terminated. I think I'm gonna get it more with your colleague there, because you seem to be, fortunately for you, you can't concede what the law is if you're wrong. The law deals with the first is jurisdiction, first of all. So I won't take up any time because you didn't argue that, but as to what you're talking about, the referral, the government said a referral is just for removal because they said, we've already terminated asylum. Matter of fact, the government is arguing in this case that the IJ had no jurisdiction or authority even to consider the matter because asylum was already done deal. And that's the whole theory, that it must have been a new application for asylum because the first one was done before it got to the IJ. We're going to get into that later, but I'm just curious that you bypassed these regulations, CFRs. Congress didn't give that authority to come up with regulations, and the statute is clear. But we'll later. Okay, but I'm just wondering why you concede that.
I think it's a misunderstanding, Your Honor. The way that I see it is that it's a very simple issue. The applicant, Ms. Wilson, the mother of the respondent, applied for asylum. Once she applied for asylum, it became the authority of the asylum office to adjudicate that case. At the end of the adjudication, what we know is they failed to grant asylum. That's all we know. The termination is a red herring, because what happened? She applied for asylum, they did not give it to her. That's all. Since she applied for asylum and they didn't give it to her, it was referred to the court for adjudication of that case. That's what happens with a referral. That's what happens when a person applies for asylum, is inadmissible under the 212A6CI. And when she presented that case, we know that she discussed the issues that were at bar at the asylum office regarding the fraud, because she would have been disqualified from asylum if there had been fraud as found by the judge. So she did confront all of these issues. She confronted everything that was about that original application. She confronted the issues of fraud that were related to the original application. It was the original application that was being decided. Of course, I understand your argument that the INA does not permit a final denial. It doesn't, but at the same time, they can terminate their decision to grant asylum. This only means that in the end, they chose not to give asylum. It doesn't. It's a separate issue, I think, than the one that the court's making.
But counsel, if you make an application for asylum and you're denied in the first instance, there's a right to appeal, correct?
Well, if you're denied under,
just answer the question.
No, Your Honor. If you're denied under 208.14C, then there is no appeal. You cannot go to the federal court. I've tried that, and it just doesn't work.
Federal court? I'm not saying the federal court.
You can't appeal it to the immigration court either, once it's denied. And the reason is clear from 208.14C, because a denial means you're in status. A denial means you're in status. If a person is in status, then he can't be sent to the court because he has status. A referral is done when a person's not in status and is inadmissible. So the word deny, it has a different meaning under these regs than it does under the INA.
All right, great. Are you finished?
Sorry, Your Honor. So again, I wanted to look at 208.14 one more time. And we can see from this section that the asylum office has 4 options, unlike the 2 that the immigration court has. The options that the regulations give them are to grant, to deny, dismiss, or refer. As long as the case is in their custody, they're tasked with choosing among these 4 options. Among these options, we know she was not approved. We know she was not approved because the approval came, it was terminated, those 2 cancel each other out. They still had jurisdiction, it was not approved. Because it's not approved, then you take a look at the next sections. If it's not approved, they have to deny, dismiss, or refer. Thus, the asylum office, while they still had jurisdiction, the approval came and it was gone. The DHS was misled by the fact that this intermediate step, the asylum approval before termination, was initiated and their jurisdiction ended. That's why I call it an intermediate step, because they have the initial jurisdiction over the claim. They have the initial jurisdiction over the claim. So during that initial jurisdiction period, it doesn't matter that it was approved, denied, approved, denied. They can do whatever they want during the time that they have jurisdiction. At the end of their jurisdiction, we know that she was not approved. Therefore, they continue to have the obligation to deny, dismiss, or refer. The asylum application remained in the hands of the asylum office through the time of the approval. Since the approval was not the final option, to deny an application, this is done when an applicant is in status, as it's shown in the regulation. They may dismiss an application, and a dismissal is done when an application is not granted, but removal proceedings may not be initiated, or they may refer an application. 208.14c1 states that in a case of an applicant who appears to be inadmissible or deportable under Section 212A or 237A of the Act, the asylum officer shall refer the applicant's application to the immigration judge together with the appropriate charging documents for adjudication in removal proceedings. Mr. Noro and his mother appeared inadmissible and deportable upon the final adjudication of the case. Therefore, referral under 208.14c1 is the only option that was available to the asylum office. This would have been the same if he were terminated for any of the other reasons that termination exists. Reasons for termination are included in 208.24. As the court said, there are multiple reasons for termination: a showing of fraud, a change of circumstances, criminal reasons, and all of these reasons, whether it's terminated for fraud, whether it's terminated for criminal reasons, whether it's terminated for change of circumstances, it doesn't change the fact that when that termination happens, then the jurisdiction ends. Prior to the time that the jurisdiction ends, the notice to appear is filed. So it doesn't matter that it was granted and then terminated. What matters is the asylum office chose not to give asylum. Mr. Noro entered the U.S. when he was 14. In 2006, he began living as an asylee. He obtained his status based upon his mother's approved asylum claim based upon her politically motivated fear and her continuing fear of detention. When the asylum office, years later, obtained information that seemed to call that approval into question, they still had jurisdiction over the case. They never lost jurisdiction over the case. Because they continued to have jurisdiction during this topsy-turvy period of approval and denial, it doesn't matter that the approval came, that the termination came. What matters is at the end of their jurisdiction, they did not approve asylum. They handed over jurisdiction to the court, and they should have referred it when they did that, because they must have denied it, dismissed it, or referred it, and denial and dismissal are not options. So, so another argument.
I think your time is up.
Oh, I'm sorry, Your Honor.
Yeah. All right. Okay. Mr. Perkins?
Good morning, Your Honors. May it please the court, I'm Paul Perkins on behalf of the Attorney General. The petitioner was deported earlier this year after the Department of Homeland Security terminated his derivative asylee status, after he conceded to removability, and after he submitted and then withdrew his own asylum application. Petitioner now asks this court to find that his removal proceedings should be terminated because even though he is now an adult, he is nonetheless eligible for derivative asylee status reserved only for children through his mother's newly granted asylum application. But this is the same argument that both the Immigration Court and the Board of Immigration Appeals already rejected, and that this court already determined did not warrant a stay of removal. Because the petitioner urges an interpretation of the applicable regulations that are contrary to a plain reading, and the board's implementation of those regulations was not manifestly contrary to law, this court should deny the petition for review. Now, as the petitioner's counsel just explained, the central question, in fact, the only issue before the court now, is whether the applicable regulations, 8 CFR 208.14 and 208.24, require an asylum officer, after approving an application and granting asylum, and then subsequently terminating the grant of asylum and initiating removal proceedings, must also refer the underlying asylum application to an immigration judge to perform a de novo review. According to a plain reading of these regulations, the answer is no. The regulations provide two separate processes: a process for the initial adjudication of an application, and then a separate process for termination of the grant of asylum. So we'll begin with 8 CFR 208.14 B and C, where we see DHS's process for adjudicating asylum applications. And what we see in B, first we see two separate tracks. And in B, we see that an asylum officer can grant an asylum application. In C, we see that if an asylum application is not granted after an interview, that the asylum officer must deny, dismiss, or refer the application for adjudication and removal proceedings. And in C1, as the petitioner's counsel already explained, in C1 we find that the application is referred for adjudication and removal proceedings when the applicant appears to be inadmissible and deportable. And now there are two issues I want to discuss here in this particular regulation. So the petitioner claims that once an application is terminated, that the application essentially becomes non-adjudicated again. It essentially goes back in time to when the application was initially filed, before it had been approved and before it was then terminated. But there's nothing in 14C to suggest any sort of process beyond the initial adjudication of an application
Mr.
after it's been
Perkins,
filed.
can I, Mr. Perkins, Judge Diaz here. Chief Judge Gregory asked the question of your colleague on the other side about the authority of the DHS to actually terminate applications. Can you respond to that? I mean, it seems clear on the face of the regulations, but there may be an inconsistency here with the statute. Can you address that?
Right. So I'll begin with the petitioner has not raised this issue, didn't raise this issue below to the immigration judge, to the Board of Immigration Appeals, has not raised this issue now to this court, has in fact conceded that DHS has this authority to terminate an application.
You can't concede that. Counsel, you can't concede that. We determine what the law is. This is a jurisdiction. You raised the question yourself because you said that the IJ had no jurisdiction to even consider once it had been terminated. So it's before the court. And go ahead and proceed with in terms of statute. Tell us exactly, as Judge Diaz said, I brought it up because that obviously Mr. Roberts didn't think much of it. But the point there is that what is the statutory authority for DHS to terminate asylum?
Sure. First, let me say, because this issue has not been raised, it hasn't been fully briefed. In fact, it hasn't been briefed at all. So if there are any arguments I don't bring up right now, we're not waiving those arguments. And also I would say that both the Fifth Circuit and the Third Circuit have held that an immigration judge doesn't have jurisdiction to review a termination decision. The Board of Immigration Appeals, in matter of ASJ, has held the same thing. And I know this issue has been briefed in the Ninth Circuit before. And so the arguments we raised in that case are, in fact, I think Petitioner's Counsel made this argument, which is the grant of authority to DHS to grant asylum in itself carries with it the ability to then terminate that asylum.
Where did you get that from? What's the statutory authority for that?
Well, again, this is an argument that
it's an argument
not briefed here.
It's an argument that makes no sense because you're saying that if it's statutory, if Congress gives you the power to grant something, automatically you can deny it. That's not in any framework of statutory instruction or the law. The point is, it does not give DHS the authority to terminate asylum, only the DOJ. And when they changed the law in 2005, they made it very clear that the DOJ can grant and terminate, but it specifically said in terms of DHS could only grant. You have no authority to do so. And under the framework of the CFRs is of no moment because Congress never gave you any assignment to make regulations to interpret the statute. And it's a clear statute, and it's deliberately kept from you. Because Congress could have changed that because it set forth you can grant, they can grant, you can grant, but deny is only, and it makes sense because that when you talk about terminating someone's asylum, should be more than no disrespect than an officer doing it. There's a whole rubric under the Attorney General and the DOJ for Article 1 judge to look at those things. So Congress never gave DHS the authority to terminate because you need that because the whole point you would have said had to have ended her asylum And even though she won before the IJ, it had to have been a new application. No, you never had the authority to terminate her asylum. What you did was you looked at it and you referred it for removal, but you could not terminate the asylum. And you can't show me anywhere where you have been given that authority to do so.
I understand the point you're making.
No, I'm not making a point. I'm making a point of something. That's the law. We act under the Congress. We don't make up the law. We interpret the law. It is clear. Congress specifically did not give you the authority to terminate asylum. Only the DOJ can do that. You can grant it, but you can't terminate it.
I understand, Judge Gregory. I would say that the Fifth Circuit and the Third Circuit and the Board of Immigration Appeals have disagreed with the position you're articulating. And I will say that the Department of Homeland Security can't just revoke, terminate asylum for no reason at all. There are legitimate reasons. For example, in this instance, in 208-24C1, we find then the granted asylum can be terminated based upon a finding of fraud such that the application should have never been granted to begin with.
I apologize because this is not an issue that I'm very familiar with, but why wouldn't we look and maybe I'll just need to do more work on this. I don't want you to speculate, but why would we look at 6 USC 271B3, which gives DHS the authority to adjudicate asylum applications? And if we go back to sort of the prior case where we talk about sort of fraud and the inducement of a contract is void at initial sort of time. And in the same way, if we can adjudicate an asylum application, if there was fraud in the initial adjudication, then the initial adjudicator can remedy that by saying at the time it was first granted, it was based on fraudulent conduct, and therefore the asylum application that was previously granted was based on fraud and therefore is ungranted, which is another way of saying terminated. But why?
Excuse me. Yeah, that's exactly right, Judge Richardson. In fact, that's sort of the point, although less articulately, that's the point I was trying to make when referring to 208-24C1, where the Department of Homeland Security has the authority per that regulation to terminate a grant of asylum on the basis of fraud in the underlying application. So I think you're exactly right. The point I was trying to make, if I could move on.
But even if that's right, that would only be for the purposes of the officer making that determination. But the referral would have to be due process for the IJ to look at that. It wouldn't automatically terminate. Because think about that. All you have to do is make an allegation of fraud. You adjudicate it with a non-title, Article 1 judge. You make this determination by an officer. And then that ends, and you go and find out that it was a bogus reason for the fraud, then they have to go all the way back. The problem is the persecution that was the basis for the asylum, no telling how many years ago, may be very difficult to then accumulate that. And then a derivative asylum, as here, Mr. Nuru, is lost. The whole idea, that's why Congress did not give you the right to terminate. Yes, you can adjudicate. You can adjudicate many things. You can determine whether how much this and that, but that doesn't mean termination. And it specifically said only DOJ could terminate. Because it's parallel these other things you're talking about, but the parallel stops with termination, and it makes sense because you can't terminate it. You refer it that there's reason to believe there's fraud, and we're referring this for removal. But the question ultimately of whether or not it should be terminated is for the IJ. And that's what Congress meant, and that's what it said. We know the world might construe by its wit, but we must construe by the law. And the law is based on the Congress. Everything else, we always say, we're a passive branch of government. We adjudicate, interpret what Congress did. And Congress made it clear that DHS, an agency with officers, cannot terminate asylum. Asylum is very precious. Asylum is so precious that even our court, an Article 3 court, we can't even grant asylum. Even if we determine that it was totally done wrong. We'd have to go back and back because only the Attorney General can do that. We can't even as a court, as a remedy. And that's why Congress did not give DHS officers, prefects, the right to terminate. Yes, you can adjudicate. Adjudication comes along. You look at the application, you do those things, you decide whether or not you're going to purge, whether or not you're going to not. But termination is special. And Congress made it special and re-emphasized that in 2005 when it changed the ID Real Act and said, you only the Attorney General. And you know that. And you know about the Ninth Circuit case. And I agree with you, counsel. It was not briefed. Again, Mr. Robert, that's why I could only mention it to him and couldn't even talk apparently only to you as well. But you have to look at the law. And you can't even not brought up, this court has to follow the law and what Congress allowed. Not what lawyers, what their preparation is or what their arguments are and what's there. It's what Congress did. And you had to do it. Those cases you cite, none of them really looked at that. I just looked at those cases. None of them grapple with the idea of Section 1158. That's where it starts. So you can't do something that you had no right to do that Congress never gave you to do. And that's why her asylum never ended. It never ended. And when she had a chance to have a due process hearing on the issue of fraud before an Article 1 judge, as Congress laid it out, she prevailed. There was no fraud, no proof of sufficient fraud. And her asylum never ended because you couldn't terminate it. That's why you're left with that. So, but I understand you may not know what the law is in terms of that. You're not ready for that. And that's not your fault because I guess that wasn't teed up properly for you. That's why you always start with jurisdiction. I tell all my law clerks, the first thing an Article 3 judge is determined, do we have jurisdiction to handle this case? No matter what the merits are, how much we might like and enamored by your arguments, if we don't have jurisdiction, you didn't have jurisdiction to terminate. And the determination is not there, it never ended, and he still has derivative abilities as that. Because think about the alternative. The alternative is that you could just have a fraud and then it's terminated. And then you got to go back, well, you won your case, you win the battle, but you lose the war. And how would he ever be able then now to go back since he's been here all these years around the states, show persecution in that country? If you think about it, it makes sense why Congress didn't give that. It really does. It's a sense of justice that Congress did that. They know they were DOJ has a whole scheme laid out. DHS doesn't. They just sort of, okay, you're terminated. Apparently not very good reason when the IJ looked at it.
Well, so a couple points in response, Your Honor. I do understand what you're saying, but what I will say is that the grant of asylum by a Department of Homeland Security is entirely discretionary. The department does have authority to grant, as we already discussed, to deny, to dismiss, to refer asylum applications. So that authority is inherent within the department's, within the regulations and within, we would argue, the statute by its very nature, because it gives the department the authority to deny, to dismiss, to approve. There is, but I've already been, yes, Your Honor.
Mr. Bergen, I'm sorry, I'm still trying to get caught up. So as I understand the state of play, the regulations permit termination. The argument that the chief has laid out is that the statute doesn't permit the regulations. And I guess the question I've got and haven't thought through is where the regulation is in place and it permits termination. There's been no challenge under the APA to the regulation. Aren't we bound by the regulation absent a challenge under the APA? The APA provides the avenue for challenging regulations. There's been no such challenge to the regulation. Can we then invalidate, absent argument here, the regulation that permits termination?
That sounds right, Your Honor. Again, this hasn't been fully briefed, and so I don't want to speak out of turn. As far as I know, the regulation has not been challenged under the APA. That's certainly not part of this petition for review. This argument, as I said, it hasn't been raised. But one other point
But counsel, you know that's not required. Only Chevron deference we have to give you. And here, you can't come close to making a Chevron deference argument because the statute is never laid out. And the APA process, that occurs when Congress gives you the authority to promulgate regulations, and there's a procedure for looking at that and review and consultation. That would have happened. But here, you never were given task with that. That's why there's no APA challenge, and there's no Chevron deference. We're looking at the elements of that. Those are your assignments. So we don't defer to it. And the statute is clear. And in 2005, I don't see how Congress could have made it clear. It couldn't have been an accident, a misstep, an oversight. No, we said, no, DHS, you don't, you're not giving you the right to termination. It's one thing that's key. You can adjudicate, you can, what it says, you can deny it, you can refer it, and those things like that. But once you do grant it, it's a property interest. Is it absolute? No. It's not absolute. But when it comes to terminating, it's Congress said only the DOJ can do that. That's how precious it is. That's a very important part. It distinguishes America from a lot of countries in that asylum. And it means something. And it's important. And you just can't whisk it away because it comes from Congress. And that's why the Attorney General has those authorities. And it's not here. And I understand, I appreciate, counsel, you're not ready on it. And maybe we can do something about it. I don't know. In terms of maybe give you a chance to look at it, but I don't know. But the law is, I think, pretty clear in terms of the authority. You don't have it to terminate. All right, go ahead.
Thank you, Your Honor. Yes, I understand the point you're making. If the court is inclined to rule in that direction, I would ask that you ask the parties, or I'm not even sure this is the right vehicle for your holding, because the petitioner has conceded and in fact has, it appears, endorsed our argument that the
saying that he can't concede. Well, you can't concede the law. It's like you can't concede jurisdiction. You can't concede.
Understood. Understood. The point I'm trying to make is, if you are inclined to rule in that direction, we would ask that you give the parties an opportunity to brief that particular issue, because as I've said several times, that issue has not come up at all in this case. And I understand that it's an issue that that you're interested in. And so I would ask that you give the parties an opportunity to brief that issue. If we could get back to the regulations, another point I wanted to make about 208.14 B and C is that when under 14C, when an application is referred, the immigration judge has jurisdiction to adjudicate that application. And the reason is we can see in the language itself that upon referral, so when an application is referred, it is referred for adjudication in removal proceedings. And so the immigration judge has jurisdiction at that point to review and to adjudicate the application. That's actually the same situation that any alien would be in removal proceedings who wants to seek asylum. At that point, they would file an asylum application with the immigration judge. And the reason that's significant is, as we've talked about many times in the past 15 minutes or so, the petitioner has conceded that the immigration judge does not have jurisdiction to review the termination decision. So under the petitioner's reading of the regulation, what we have is, after DHS approves an application and then terminates the grant of asylum and refers it to an immigration judge, the immigration judge does not have jurisdiction to review the termination decision, which in this instance, it was a determination that the application should have never been granted to begin with because it contained fraud. So there's no jurisdiction to review the termination decision, but there is jurisdiction, according to petitioner, to perform a de novo review of the underlying application. So the problem with petitioner's argument is that those reviews are effectively the same thing. They're both looking at the underlying merits of the application. So we would submit that the only reading of 208.14 B and C that makes sense is that they speak exclusively to DHS's initial adjudication of an application. If I could take a few minutes to also talk about 208.14 E, and by reference 208.24, which set out the process for terminating a grant of asylum. And the language in those regulations provide that any grant of asylum is subject to termination upon a showing of fraud in the application, such that the application should not have been granted, And then at that point, upon termination, DHS shall shall initiate the removal proceedings as appropriate. And so 2 points here that I want to make. First, there's no requirement or no inference at all in this language that upon termination of an application, that application is then referred to an immigration judge for a de novo review. And there's no suggestion that an application upon termination returns to its initial status upon initial filing. And the reason that point is significant is because if DHS had wanted to include this referral process after termination, they would have said so. And we know that because that language is included in 208-14C1. As we've already discussed, that's where it provides that the asylum officer shall refer the application to an immigration judge for adjudication and removal proceedings. That language does not appear in 24A1. The language there simply provides that the agency shall initiate removal proceedings. It says nothing about referral of the application. And that makes sense because by definition, when a grant of asylum is terminated, that means that the asylum application has been adjudicated. It can only be terminated after it has been approved, after the application has been approved, and only after an asylum officer determines that there was fraud in the application, such that the application should have never been granted. Therefore, we believe that 208-14E and 208-24 provide the process for termination of asylum granted under 208-14B, and that once terminated, an asylum claim is over, and there's no language to suggest otherwise. Now, this interpretation of the regulations is entirely consistent with the Board of Immigration Appeals decision in matter of ASJ. Now, in that case, the facts are similar to this case. The petitioner applied for asylum, the alien applied for asylum, was granted asylum. 10 years later, the grant of asylum was terminated. At that point, the removal proceedings were initiated, and the immigration judge in that case did look at the termination decision to determine whether it agreed with that decision. It did not, but the Board of Immigration Appeals, in reviewing what the immigration judge did, determined that the immigration judge did not have jurisdiction to review the termination decision. And importantly, the BIA held that the alien did have a right to reapply for asylum, to file a new asylum application. This is consistent with the Fifth Circuit's understanding of these regulations, consistent with the Third Circuit's review of these regulations, and that's the exact process that played out here.
And counsel, but in ASJ and those others, they never looked at the statute 1158. They didn't interpret the statute at all.
I understand.
They didn't, right. They never addressed the issue. It's like hidden in plain sight. Everybody's all running all around with DHS, and of course, all this is post 9/11, and DHS was formulated under that whole different rubric. But that's why Congress said no. But still, there's due process left. That's why this agency does not have the right to terminate. And none of them looked at 1158. None of them.
Right. And again, as I've said before, our interpretation of the statute is that giving DHS the authority to grant asylum, within it, there's an inherent authority to evaluate whether that asylum should or should not have been granted somewhere down the road. And per the regulation, upon a finding of fraud, the grant of asylum can be terminated. So for all these reasons, we submit that the board correctly concluded that the petitioner was removable and termination of his proceedings was not warranted. This conclusion was certainly not manifestly contrary to law. If there are no further questions from the court, we therefore ask the court to deny the petition for review.
Thank you, counsel, for your argument. Appreciate it.
Thank you.
Mr. Roberts, we'll give you some time.
I'll be very brief, Your Honor. The question is whether the DHS can send a case to the court without a referral. As the government just said, it's over, the government said, when it's terminated and cannot be referred because it's over. In my earlier arguments, I explained why it's referred. However, the Chief Judge has also explained why this argument cannot succeed, why it cannot be over when it's sent to the court. This is because The DOJ can grant and deny asylum, but the DHS can only grant. They cannot deny a case. If termination meant it was over, then termination would mean that the DHS has the authority, the statutory authority, to deny a case, which they do not have.
Well, I think they actually do have the authority to deny. Well, I thought the chief's point was that once granted, they can't terminate. And I don't want to speak for him, but.
I don't know what Mr. Roberts is talking about. Yeah, but yeah, that's the point, the termination. Anything further, counsel?
No, Your Honor.
All right, thank you. All right, thank you so much, counsel. We can't come down and greet you, shake your hand, but know that we very much appreciate your argument, and thank you so much for helping the court with these very thorny issues. And we ask you, hope that you will stay safe and be well. Take care.
Thank you.
Thank you.
Bye-bye.
Thank you.
All right. Mr. McBeth?
Good morning. May it please the court. My name is Isaac Macbeth. I represent the appellant in this case, and I'm here to plead the cause of a man who was unable to do it for himself in the hopes that similar tragedies might be avoided in the future. This is a case in which the district court granted a Rule 12b6 motion dismissing a case in which a man who was clearly suffering from prescription medication overdose received no medical attention from the officers who arrested him. The claim that was asserted was a 14th Amendment deliberate indifference claim, and the district court dismissed the claim on two separate bases. It found, as to the merits, that the complaint had failed to plausibly allege a 14th Amendment due process violation, and it also found that the officers were entitled to qualified immunity. Now, before I address those points, I want to flag something at the outset for the court. There was an argument that was raised on brief that in my preparations, I believe is not well taken, and I will not be advancing today. That argument is on page 9 to 10 of the appellant's reply brief, where it was argued that supervisory individuals in their individual capacities can be subjected to claims on a Mon-El standard of liability. We will not be arguing that position today. We don't believe it to be well taken. Nevertheless, there is a compelling case for reversal in this case. The district court, as I said, granted dismissal on the merits and on the basis of qualified immunity. And it's important to keep those two grounds of dismissal separate because as to the former, the law of decision would be the current law, meaning that if Kingsley, the Supreme Court's decision in Kingsley altered the 14th Amendment standard of liability, that standard would govern the merits analysis. Qualified immunity, by contrast, is analyzed under the law as it existed at the time of the alleged infractions. And so it's important to analytically keep those two things separate. Turning first to the merits dismissal, appellant contends that the court erred in not finding that Kingsley modified the standard for a due process violation under the 14th Amendment. The reason that we believe the district court erred is that although Kingsley was a 14th Amendment excessive force case, the reasoning in Kingsley really dispels any reason for continuing to include a subjective element in a 14th Amendment deliberate indifference claim. The Kingsley court reasoned that the subjective element finds its origins in Farmer v. Brennan, an 8th Amendment case. And the reason that that element was incorporated into the deliberate indifference analysis in Farmer v. Brennan is subjective awareness and intent is a necessary condition to infliction of punishment. which is obviously what the Eighth Amendment is concerned with, the cruel and unusual, infliction of cruel and unusual punishment. Kingsley's reasoning, however, made clear that while punishment would run afoul of the Due Process Clause, as pretrial detainees cannot be punished under any circumstances, punishment is not a necessary predicate to recovering under the Due Process Clause. And so the end result is that if there's no, if the only reason for the subjective component of deliberate indifference is to prove that punishment occurred, and punishment is not a requisite showing of recovery under the Due Process Clause, the basis for a subjective requirement in 14th Amendment deliberate indifference claims evaporates. And we think that that conclusion is further underscored by the language of Farmer itself. In that case, the court said the Eighth Amendment outlaws cruel and unusual punishments, not unusual.
Counsel, can I ask the question? So how does that square with Bell, where the Supreme Court does seem to say that the Due Process Clause turns on whether there's punishment? Now, not whether it's willful and wanton, I get that, but you said that punishment's not a predicate under the Due Process Clause. I took Bell to say the opposite. Why am I misreading Bell?
Well, Your Honor, I think that Kingsley made a direct observation on that and said that while Bell used language that focused on punishment, the analysis in the case nevertheless said, even where punishment could not be shown, the pretrial detainee could prevail by showing that the excessive government action was not rationally related to the interests at stake. And so Kingsley said, therefore, punishment would not be necessary, notwithstanding the language of Bell focusing on that. And so I think the answer to the question is while Bell does use language that contemplates punishment, its reasoning also qualified that to say, even in the absence of punishment, an objective violation could be shown by testing the government action against the rational interests involved. Okay. And then also in Farmer, I think that these two quotes really particularly underscore just how closely tied.
I'm sorry, because I didn't want to interrupt, but I couldn't find it. But that's not exactly what Kingsley says, right? Kingsley says that where you can't show an intent to punish, that you can infer that where the actions are not rationally related. But that's about the intent to punish, not whether there is an existence of punishment. As I read Kingsley, it correctly says that Bell is not about an intent to punish, but it still requires punishment. And that's because the actions are not rationally related allows that inference. Am I just reading that wrong? I'm sorry.
That's not how I read it, Your Honor. What I understood was that intent and punishment are necessary concepts to each other. That is to say, there can be no punishment without intent. That's the relationship between those two ideas. And so as the way that I read Kingsley was saying, in other words, you could never have a situation where punishment occurred without the requisite intent. That was the point that Justice Scalia made in Farmer, was you can have all sorts of reckless conduct, but without an actual intent to inflict punishment, it's not punishment. And so I don't think that analytically you could separate a situation where one does not have an intent to punish and still find punishment. I think that those two realities can't mutually coexist.
So how does that move the ball in this case? What's the sort of the end result of that conclusion?
Yes, Your Honor. So how that would particularly impact this case is that it would require the revision of the current deliberate indifference standard employed by the Fourth Circuit. Currently, we use the Eighth Amendment Farmer v. Brennan standard, to adjudicate medical deliberate indifference claims under the 14th Amendment. Kingsley's reasoning, however, would counsel that although the objective medical need component would remain the same, simply because that's the constitutional right to care is for medical needs, not elective care, the subjective component would be revised to reflect that the government actor had engaged in purposeful, knowing, or possibly reckless conduct that was objectively unreasonable. Thereby,
but getting back to Judge Richardson's question, how does the sort of an objective failure to meet someone's medical needs equate to punishment?
It doesn't. I don't think that an objective, without an intent to inflict punishment, the conduct can't be punishment. That's what, or without the intent to disregard the substantial need and the attendant risk, the government's conduct can't be punishment. So if there's no intent to disregard the known risk, then the conduct isn't punishment, no matter how egregious it is.
But it remains a violation under the Constitution, not pursuant to the 8th Amendment, but pursuant to the 14th Amendment?
That's right, Your Honor. That is what we understand that Kingsley would endorse, is that even where conduct has
but of course, Kingsley dealt with a excessive force claim, which by implication suggests some overtones of punishment, right? Doesn't it?
Well, I think that it, I think that it has been traditionally understood that excessive force that would meet the definition of punishment would violate the due process clause. But I think that the entire, as we read Kingsley, the point was punishment is no longer a requisite showing to due process recovery. So I think that that's what's changed in the light of Kingsley, is whereas prior it was, the metric was conduct that would amount to punishment. In the post-Kingsley era, the due process clause would not require punishment to be at play. So long as you require punishment to be at play, the subjective intent would still be required as well. You can't cleanse the standard of subjective intent and still require punishment to be shown, because you've basically eliminated the foundational requirement for showing punishment at that point. So I think, to answer your question, Your Honor, we would say no, that Kingsley took excessive force away from the direction of punishment and instead said that conduct that would be objectionably unreasonable would be an affront to the 14th Amendment due process clause.
I don't mean to cut that off, but can you then turn to the next question that you began with, sort of saying, assuming we agreed with you, or frankly, if we disagreed with you on this first step, can you talk about what that means for the second step? If Kingsley did require revision of the standard, or if we disagreed and it doesn't require revision of the standard, what effect that has on the second step and how that's analytically distinct here?
Yes, Your Honor. So the second step of the analysis, or the second basis of the court's dismissal, was qualified immunity. And so how you adjudicate or rule on Kingsley, either way, does not affect the qualified immunity analysis, because the law is clear that qualified immunity looks to the law at the time of the offense. So even if the court were to conclude, while the 14th Amendment does apply a different standard, we would judge the officer's qualified immunity by how the 14th Amendment had been interpreted at the time, which was to be lockstep with the 8th Amendment deliberate indifference standard. So the question doesn't impact the analysis either way under qualified immunity. It would only impact the plaintiff proving its case at trial, or the standard that the case would be judged at summary judgment.
Perfect. So that's exactly the question I want to get to. Assume I agreed with you hypothetically that Kingsley applies objective standard at step one. Step two, effectively, let's just call it a subjective standard, the Farmer standard applies. And we show up at trial, the judge has to instruct the jury on the subjective standard, right, in order for you to actually get money.
No, what would happen if you change the standard under Kingsley, the judge would have to instruct the jury on the new objective standard for the plaintiff's claim. However, the defendant asserting qualified immunity would receive instruction, assuming there was some disputed fact that the court needed resolved for qualified immunity.
Right.
The jury would receive instruction on that subjective standard, because that would be the standard that qualified immunity would be judged under, or the court may just propound a special interrogatory to resolve whatever factual issue it needs.
So it'd be like an affirmative defense. So in other words, to establish your claim, you got to establish objective, and then the defendant will come in and say, there's an affirmative defense where they didn't subjectively know this, and that would be sort of a special verdict form of some sort, assuming material facts were at issue. Okay, that's helpful. Thank you.
Yes, Your Honor. I wrestled with the same concept. I was trying to.
Sorry, I didn't mean to cut you off. Go ahead and finish your answer to Judge Richardson's point.
I was just musing, Your Honor. I'm done.
So, this discussion between you and Judge Richardson sort of highlights the concern I have about this case regarding qualified immunity. You seem to be suggesting that somehow gets to a jury, but isn't the very notion that we've had to go through these iterations, interpret Kingsley, to get to a newfound rule of law that now changes a subjective intent to an objective intent, suggests that these officers can't possibly be liable because they could not have predicted this change in the law?
Yes, Your Honor, I understand that question, and it's a question that I've put a great deal of thought into, and I believe the answer to your question is no. It does not automatically follow that because you've changed the standard from subjective to objective, that they would not automatically get qualified immunity. And what's interesting about that, Your Honor, is that exact issue was argued in Kingsley back on remand to the Seventh Circuit. And the Seventh Circuit rejected that argument. And the reason for that is, Your Honor, the defendant can still prove its affirmative defense under the law that it's as it existed at the time. And so the defendant isn't losing the benefit of qualified immunity or being tested or exposed to liability or having the standard for immunity changed on them by you changing the standards of the merits of the claim. The defendant still gets to pursue qualified immunity under the deliberate indifference standard that existed at the time. It may be that the judge only needs the jury to resolve a few isolated facts and then make the immunity analysis for itself as a matter of law, but it wouldn't change the fact, it wouldn't require that the merits claim be dismissed simply because the court has changed the standard for the merits claim. The qualified immunity standard remains unchanged. In other words, sorry, Your Honor.
No, go ahead.
In other words, if the defendant was able to show that notwithstanding the change to the 14th Amendment standard, the officers were not subjectively aware of the risk and subjectively disregarded the risk, they would still be entitled to qualified immunity even if the court changed the standard for the merits under Kingsley.
Counsel, what if Kingsley was just off the board? Do you think you can't meet the deliberate indifference standard here under these facts?
No, I believe very much we can, Your Honor.
But wouldn't it be better for you for us not to reach Kingsley and get it off the table and not address that issue at all? And just assess your case on whether or not it was correct or incorrect to grant summary judgment or qualified immunity based on deliberate indifference. And even at trial, that it would be that standard even for damages or liability to before the jury. Wouldn't it be, because as Judge Diaz alluded to or commented directly, that implicates, maybe this is so up in the air and loose in terms of standards that it's not clearly established. But what's clearly established, whether or not there's a constitutional violation in terms of whether or not you can allow somebody who seems to be clearly in need of medical attention and put them in a cell. That's that question there. But then actually, what did the officers know? So if you think that you can do that by deliberate indifference, then why do you bring in Kingsley to potentially hurt your case?
Well, it's, I suppose the short answer to the question, Your Honor, is it would hurt the case if the conclusion was that revising the standard under Kingsley would require the grant of qualified immunity because of the ramifications for clearly established law. And in that way, then I would agree, yes, Your Honor, it would be best to test the case under Farmer's deliberate indifference standard. That's the answer that I have to your question. I don't know if that fully answers it.
Well, you answered it.
I just want to make sure I understand, because I think I understand, but I'm not certain. So if we agreed that you had enough evidence to meet Farmer, right, in contrast to what the district court said, at least at a motion to dismiss stage or summary judgment probably too, but if you've met that Farmer standard, are you asking us to, or would you, how do you phrase what you're asking us to do? Would you would prefer to try the case under Farmer than be dismissed under qualified immunity? That's basically what your response to the chief is.
Exactly, Your Honor. I think that, and in some...
We can do that. We can sort of duck question one, because either way at trial, either as a affirmative liability finding or the affirmative defense finding, you got to show Farmer either way.
That's right, Your Honor. And so I think that can implicate the doctrine of mootness in the sense that we need not decide the Kingsley question because the subjective standard would be at play in the merits regardless.
Although the burdens are different, right? Because
that's right.
In the hypothetical we've decided, or we've not decided, but we're positing here, you would then bear the burden under Farmer, where under our earlier hypothetical that we talked about, the defendant would bear the burden under Farmer as affirmative defense after you bore the burden under the revised Kingsley standard, whatever that is.
Well, that's actually, so that's a unique aspect of qualified immunity, Your Honor. And this court in Henry v. Purnell said the way that the defense works is the plaintiff bears the burden of proof in establishing the first element of saucier, and then the defendant bears the burden of proof on clearly established. So we would actually, even though they're asserting the affirmative defense, we would have the unusual twist of we would still have to prove the violation under the standard applicable to qualified immunity, that is the Farmer standard.
Wait, say that one more time. I'm sorry, Chief, for taking time.
No, go ahead, sure. Go ahead.
I understand this. Say that just one more time. I just want to make sure I followed it.
Yes, Your Honor. So the way that the Fourth Circuit's interpreted the burden of proof with the two-pronged saucier test for qualified immunity is the plaintiff has the burden of proof on the first prong, that is whether a violation occurred, and the defendant has the burden of proof on the clearly established requirement, the second prong of the saucier analysis.
And your point is that I'm not sure I follow. So what does that mean for the jury instructions? Does that affect the point we just made about the burdens being different?
Yes, it does, Your Honor, because basically we would need to prove a violation for purposes of qualified immunity, which would be the Farmer standard. And then we would, if the court changed the law, prove our case in chief, which would be under the revised standard that the court formulated if it formulated one. So in essence, the jury would be instructed that we would have a burden to prove the subjective intent, but it would be in connection with their affirmative defense, not with our case, our merits, our case in chief. It's a odd nuance to qualified immunity.
And so the essence there would be that the district court might well say, we're only going to instruct on subjective intent because we know from Bell, for example, that subjective intent necessarily satisfies objective intent. And so rather than require the jury to find both, we simply instruct on the higher burden, and that resolves your case on the question of whether you meet Farmer. If you do, you win. If you don't, you lose. But that's going to be true no matter what we do.
Exactly right, Your Honor.
Thank you, Chief.
I see I've run over my time. I had intended to reserve a few minutes for rebuttal, but I think that ship has sailed. So if there's any other questions, I'll field them, and otherwise I'll cease my argument.
All right. Thank you, Mr. Macbeth.
Yes, Your Honor.
Mr. Dadak.
Yes, Your Honor. May it please the court. Chris Dadak on behalf of the appellees. I want to address and start at the merits as the appellant did. There's a slight twist of his case is that the district court, even under the farmer standard, there's an objective prong and a subjective prong. And the district court, in its opinion, talked about the objective prong is the serious medical need, and that's diagnosed by a physician needing treatment or easily recognizable by a layperson. Then it goes on to the subjective standard that much discussion focused on. But the district court in its ruling found that based on the allegations, the appellant had failed to show that the medical need was sufficiently obvious, the objective prong, or that the defendants actually knew of and disregarded the excessive risk, the subjective prong. So the district court found that the appellant had failed to allege enough to satisfy the objective prong and the subjective prong. So our position has been that changing the standard would not change the correct result by the district court because he had still failed to allege and satisfy the objective prong. And briefly, I'll talk about Kingsley.
Tell me, just so that you don't need to belabor this because I think you've probably picked up where this is going. But why is it that you think that's right? I mean, I read the district court's decision, but why is it do you think that it's right on the 12B6 standard that neither of those are met based on the facts we've got here? And I understand that the facts might turn out to be a little different, but just in sort of brief form, why do you...
Yes, Your Honor, and I'll turn the court's attention to Grayson v. Peed, which the district court relied on, which is that there were no signs of external injuries, no difficulty breathing, no choking.
Was Grayson's the one where the guy's fighting back?
It was eventually, yes, Your Honor.
All right, so...
But...
Okay. I mean, he's fighting back, right? As opposed to the guy virtually comatose.
Yes, Your Honor, but in terms of putting the defendants on notice, and this goes a little more to qualified immunity, but in terms of the objective prong, he's being arrested for public intoxication. I mean, he has bloodshot eyes. He's at least somewhat conscious based on the allegations. He can ambulate, but with help. What we're looking for in terms of the objective need is that a layperson would have easily recognized that he has a serious medical need besides the fact that he's intoxicated. I mean, we're not talking about...
And I understand, and I don't want to belabor this point, I understand that at trial like that, you may well prevail on that idea, right? I mean, I haven't seen the guy, maybe there are videos, maybe your guys say, we see 400 of these guys a year. They all look the same and none of them have ever died before. So we had no reason to think, I don't know.
And Your Honor,
I mean, you're sort of, that sounds like a jury argument you're making or a summary judgment argument, not a motion to dismiss argument. He says, in essence, I was comatose and they should have recognized that I needed to go to the hospital. I don't know, that doesn't seem like a crazy idea to me.
Yes, Your Honor, 2 points briefly. One, I don't believe the allegation that he was comatose. He fell asleep at times and had difficulty being woken up. But the allegation in the complaint talks about him lifting his head to communicate. So we're not talking about someone who's completely unresponsive or comatose. Second, we have the allegations that he was arrested the night before for a very similar issue and had similar symptoms and did not have any medical need or require any medical attention. So,
which is going to be a very good argument for you at summary judgment or in front of a jury, right? But that's not part of the complaint, is it? I mean, he didn't allege that he was arrested the night before and had similar problems, does he?
Yes, he does, Your Honor. I mean, the factual allegations are, I mean, he doesn't exactly phrase it that way. It's just based on the facts alleged. He does allege that he was arrested the night before, that he had slurred speech, bloodshot eyes, difficulty communicating. Now, he was eventually released on his own recognizance. There's no allegations of the timing of the release. But yes, Your Honor, he does allege symptoms which we contend are quite similar to what he exhibited the following night. And that's what makes this case unique.
It's the similarity that, I'm not sure this is worth spending our time on, but it's the similarity that he doesn't allege.
Well, he doesn't put it in those terms, Your Honor. Of course, he alleged facts from the night before, Your Honor, and I will turn to the amended complaint.
I can read it. You don't need to belabor it. I got you.
But he had slurred speech, bloodshot eyes, struggled to stay awake, very lethargic, difficulty standing up. So, difficulty ambulating. So it is our position that those factual allegations are similar to the factual allegations related to the second night when he was arrested and, tragically died, Your Honor.
Wasn't it called for a medical emergency?
Well, Your Honor, again, I think Grayson v. Pede kind of...
I'm not talking about Grayson. I'm talking about this case. Wasn't the call for medical emergency?
Well, Your Honor, the call, yes, Your Honor, but that's not within the, the law enforcement officers responding to the call. That's not their decision to make, Your Honor. They're dispatched
No, but I'm saying that gives you the initial context of what they're responding to. For example, the difference between saying, I'm responding to burglary in progress, as opposed to man is down in the street, needs medical attention. That frames a context, doesn't it? I'm not saying it's conclusive or dispositive, but it frames a context for the call. It was a medical emergency call. And you answered, the answer is yes, it was. And when they got there, they saw him there lying in a bed of a truck that had water in it. He's lying in the water in the bed of the truck, right?
No, Your Honor. They found him in the actual pickup truck, Your Honor. He got moved. Yes, Your Honor. Your Chief Judge is correct. He eventually was moved to the back of the truck, and he laid down in the back of the truck, and there was water in the back of the pickup truck, Your Honor.
Right, and they put him in the water, right?
No, Your Honor. They didn't put him in the water. They moved him to the back of the truck. He sat down, and then he...
Wait a minute. They took him out of a car and put him in the bed of a truck that had water in it.
Well, Your Honor, they didn't physically... I don't want to speculate too much as to the...
That's exactly what Judge Richardson is saying. No, we don't want to speculate, but we're here at 12B6.
Well, yes, Your Honor.
Not speculate. You want us to be conclusive as a matter of law. And yet here in these facts, this oral argument, you don't even want to speculate. I'm just telling you the facts. They took him out of the passenger part where he was, or the driver's part, and they put him in the bed where there was water. There was standing water, and then he laid down in the water, didn't he? He did, didn't he?
He did lay down, yes, Your Honor.
And then there was medication, bottles of prescription medication near him when you found him, correct?
That is correct, Your Honor.
Okay, and he had, as a matter of fact, he couldn't even put his own feet down. They had to literally, physically take his legs and put it down on the ground so he could manage to get up with their help to even move him. Isn't that right?
Your Honor,
is that right?
Well, Your Honor, they allege that he needed help getting out of the car and placing his feet on the ground. Yes, Your Honor. Yeah. But there's no allegation that he was unable to ambulate with assistance, Your Honor. He also had difficulty standing up the night before, Your Honor. So, Your Honor, the difficulty is that all these signs point to someone who's intoxicated, but they do not point to someone who is in serious medical need, Your Honor, obviously recognizable to a layperson. The appellant spends a lot of time focusing on the medication and the amount of it found at the scene. But again,
just to help me understand, how are we supposed to make that decision at a 12B6, right? I mean, I get some extreme example, right? The guy has appendicitis, and so you can't recognize anything, right? Like, there's nothing to see. But, obviously, I assume you would agree at some point, people that are intoxicated need medical assistance, right? I mean, that's why we talk about people getting their stomachs pumped, right? And so the question is, where on that spectrum did he fall? Was he so far gone that he needed to have his stomach pumped or medical attention? Or was he just really intoxicated, like we might find on a college campus? I don't know, but I don't know, absent some factual development, how I'm supposed to make that decision based on the complaint.
Well, Your Honor, I would point to allegations of unconsciousness, completely unresponsive, difficulty breathing, vomiting, or obstruction of the pathway. Those are exactly the type of indications noted in Grayson v. Pede, Your Honor. And those are the type of allegations I would concede if those allegations were made, that we would likely not be here, Your Honor.
And where do I get those from? I mean, that's like, they're like legal conclusion that's the symptoms. I mean, I get that you might get a doctor or a jailer who says, supports that. But here, how do I know that that seems reasonable to me, right? But I don't, you're not a doctor. How do I know that that's the type of thing that somebody would recognize that's when they need medical attention?
Well, Your Honor, the legal standard has to be easily recognizable by a layperson. That is the legal standard. And as the district court found, the allegations failed to meet that burden, that it has to be easily recognizable by a layperson, Your Honor. And so the analysis is you look at the factual allegations, and the determination is in terms of at least the objective prong, and I'm talking, of course, under the old standard, or at least current standard. You look at the allegations, are they diagnosed by a physician as maintaining treatment or recognizable by a layperson? And what I think this case is unique in terms of the symptoms he had, Your Honor, were not easily recognizable by a layperson. Again, we're talking about law enforcement and correctional officers responding to the scene. And one thing I would like to point out, that we've given the appellant the benefit of the totality of the circumstances, but we're talking about 6 individual officers who are being sued for any interaction they had with the decedent that evening. So there is no single defendant who was present in the very beginning to the very end and witnessed each one of these factual allegations. And despite the having the benefit of that totality of circumstances, the district court still found that it wasn't sufficiently obvious. And the reason for that is, again, I'll point to Grayson v. Pede, I think it's also important for qualified immunity, is the court there found similar issues and focused on those symptoms. And so in terms of qualified immunity, the analysis is whether a reasonable official would have known that they were violating, that his conduct was unlawful in the situation he confronted. And so when you have Grayson v. Pede, which is, by the way, a finding of no constitutional violation, those officers were not on notice that their conduct was unlawful in the situation they confronted. This isn't a case of qualified immunity where we are trying to distinguish from similar case law finding constitutional violations and are relying on minor details or differentiations to say this isn't the same fact pattern. We have a similar fact pattern in Grayson v. Pede in terms of what was witnessed and what this court found was insufficient to find a constitutional violation. And so our position would be, even if the court got the prongs wrong, these defendants are entitled to qualified immunity, because in the situation they confronted, they would not have been put on notice that their acts were unlawful. And I'll point to a couple other factors that support that position. Because regardless of whether the standard remains the same of subjective or purely objective, is the state of mind has to be purposeful, knowing, or at least reckless. And in this case, the amended complaint talks about how one of the defendants called the Commonwealth's attorney and notified them of the intoxication level of the decedent. But the decedent was also taken in front of a magistrate who witnessed his level of intoxication and ordered him held until he sobered up. So there are numerous reasons for why these defendants were not put on notice that the conduct that they committed was unlawful. And again, for example, each of these defendants only interacted with the decedent over a certain period of time. Not one of them was present from the very beginning to the very end. And so for qualified immunity purposes, they have to be put on notice that their conduct is unlawful. And so our position has been pretty consistent, Your Honors, that regardless of the standard remains objective or subjective, the appellants district court correctly found in favor of the appellants because he didn't meet the objective prong. The difficulty is, for example, the appellant relies on the prescriptions and the amount of pills missing, but defendants don't know whether he actually ingested those pills, sold those pills, lost those pills. That's not a reasonable inference in favor of the appellant. On top of that, there are issues with the obviousness of the risk. And so, and I would also like to point out that, as alleged in the amended complaint, the cause of death was acute overdose of 4 substances. The complaint only alleges that defendants knew of 2 substances, which also ties to Grayson v. Peed, where there's an unknown heart condition. So in this case, we have a cause of death from 4 substances, 2 of which the defendants did not know about. So I think that's another factor that puts this case closer to Grayson v. Peed, both in terms of the merits and in terms of the qualified immunity analysis.
But you knew he had consumed prescription medication, right?
Yes, Your Honor.
Right, and you knew they were narcotics, prescription narcotics.
Well, I believe this in the second arrest, well, they were prescription medications. I do not believe they are.
Well,
they are narcotic. Gabapentin and citalopram, Your Honor.
Gabapentin is an anti-epilepsy medicine, and alprazolam we know as Xanax, is my understanding.
Yes, Your Honor, but that's what he said.
Those are narcotics.
But alprazolam is what he said he took the night before. The night of his arrest, and the pills they found, as alleged in paragraph 23 on page 36 of Joint Appendix, is gabapentin and citalopram, not the Xanax. But there are some practical issues in finding these allegations are sufficient. For example, what if they just knew he took prescription medication but have no indication of what medication it was or how much? Is the inference then that they must assume a certain amount, that it's a lethal amount? I think the more rational position is, as courts typically have in the past, is you focus on the symptoms. And again, as in Grayson v. Peed, the symptoms here do not involve loss of consciousness, difficulty breathing, obstruction of pathways, obvious signs that someone is in need of medical attention. But otherwise, every person who is arrested for public intoxication that has the symptoms alleged by the appellant will require a duty to have them sent for medical care. And in practical terms, our position would be that is an unworkable standard and a change in the law to which would entitle the defendants to qualified immunity.
Well, it seems the argument is the fallacy of false dilemma. In other words, if we do this, then it has to be all that. You take so many things out. This was a medical call. Most DUIs is that they watch people the way they observe their driving, They are driving, they're operating, and that's how 90% of them or more start. This is a case where you were called for a medical emergency. And when you came, you found out there was medication there. He was in and out of consciousness. That's not, you can't make the chicken little argument here, and that is the sky falls in this case, and everybody who's charged with DUI who stumbles. No, that's not the case. But we hope that everybody that you respond to a medical need call that presents like this is a question, it's a factual question. The jury may have to decide that, or maybe not, or whoever, or maybe qualified immunity when it's appropriate or whatever. But 12b-6 as a matter of law, that's the issue. That's the question. I mean, a lot of circumstances. It's matter of fact, police officers are not physicians. That's why they don't have to make determination in their treatment. But they have to turn to look at what you're presented with when you come there. They're protect and to serve. And even when you're intoxicated, you have a right to be protected. Matter of fact, you're still presumed to be innocent. And when you present needs for a medical need, the question is whether or not enough for the person should have known, a reasonable officer should have known.
Your Honor, I know I'm out of time. If I may briefly respond.
Sure.
Your Honor, just briefly what I would say is, again, while yes, the call was for medical attention, but it is worth noting that the magistrate saw the appellant and ordered him held until he sobered up. One of the defendants called the Commonwealth's attorney and described the situation to the Commonwealth's attorney. And in terms of whether it's a 12b-6 or summary judgment, these are the facts alleged by the plaintiff. And so I believe the district court correctly viewed him in the light most favorable to the plaintiff, and they still were insufficient to meet the objective or subjective prong, Your Honor. And I know my time is up, so unless anyone has any other questions, I will finish my argument. Thank you.
Thank you, Mr. Dadak. Mr. Macbeth, you have some time reserved.
Thank you, Your Honor. I'll be very brief in my remarks. The first thing I wanted to address was Mr. Dadak's commentary on the magistrate. Basically, as I understand the argument is because the magistrate acted in the way he did, that is, order him detained until he was sober, that somehow generates an inference that a layperson wouldn't have observed a serious medical need. And I think that inference is just not completely or not at all warranted. Virginia magistrates, just like federal magistrates, are creatures of statutory authority. They can only do certain things. There is nothing in the statutory enumerations of power given to a Virginia magistrate that would say, give them the power to direct the officers to take the person to the hospital, to take Mr. Mays to the hospital. So pointing to the fact that perhaps the magistrate didn't do that and saying, well, that generates an inference about his condition at the time is a red herring. It's a fiction, because the reality.
Well, don't you really just want to say, like, listen, we can have that argument at summary judgment or in front of a jury, whether like we think that about a magistrate or not. I don't know. It doesn't seem like a crazy argument to me, but it's not a motion to dismiss argument. I think is sort of the first line. We can discuss whether, the magistrate's finding is a useful data point for you to argue at some later point, or your colleague to argue. But the point is that like that's not the required inference, rendering all other inferences implausible for purposes of a motion to dismiss.
Exactly right, Your Honor. That's right. I think that the factual distinctions between this case and Grayson have been highlighted, and its procedural distinction is Grayson was decided on a full record. That was a case decided on summary judgment, not on a motion to dismiss, which further distinguishes that case. And I think that there's particularly a need for a full record in this case because what the obvious risks are of prescription overdose, what a layperson might consider obvious or serious, very well have changed since 1999 when Grayson v. Peed was written. That was on the left side of an opioid epidemic and prescription medication crisis. 2016 where this happened is on the other side of that. Very similar to a layperson in 2020 may view coughing and a fever much more seriously than they did in 2018 because
but you wouldn't argue that for qualified immunity purposes, if Grayson was on all fours here, the changing times would be a hard argument to putting these officers on notice for qualified immunity purposes. Isn't that an over, you don't have to go there, but why make the argument that it's changing times? The point is, from your perspective, is that Grayson's not on all fours, but if it was on all fours, then you got a really hard qualified immunity argument, I would think.
Yes, Your Honor, that's right. I think I was just trying to make the point that I think this is a decision that needs to be buttressed by an actual record, not just allegations on a complaint. And I don't want to belabor the point. And so that's all I have, Your Honor, unless there's any questions that I could field.
Thank you so much, Counselor. Thank you both. We express our gratitude for your being here. We can't come down and shake your hands, but you're very helpful in the process of trying to understand these issues, and we really appreciate your argument, your being here. And we wish you well. Be safe and stay well. Thank you, Counsel.
Thank you, Your Honor.
Thank you, Your Honors.
Chief, could we take 5 minutes?
Absolutely.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Panikowski?
Good morning, Your Honors, and may it please the Court. Stanley Panikowski on behalf of Nike. The District Court's preliminary injunction should be vacated.
Counsel, one second. Do we have the other counsel, Mr. Anderson?
Yes, Your Honor, we do.
Mrs. Anderson, I apologize. I didn't see her.
With my name, you expect that.
Thank you, Your Honor. The District Court's preliminary injunction should be vacated because there is no evidence of irreparable harm and no likelihood of success on the merits. Either one is an independent ground for vacating the PI. Fleet Feet was required to make a clear evidentiary showing of irreparable harm, but all it had was speculation about remote possibilities. No confusion, no immediate risk to its reputation, no immediate threat that customers, franchisees, or sales would be lost. Nothing that satisfied this court's actual and imminent standard for irreparable harm. The District Court itself made a factual finding, uncontested on appeal, that, quote, the lack of any indication of confusion, particularly given the broad reach of Nike's campaign thus far, calls its existence into question, end quote, at page 2017 of the joint appendix. This unusually strong factual finding is the key to unlocking the District Court's legal error on irreparable harm. This finding pointed decisively against irreparable harm. Over 18 million views of Nike's Sport Changes Everything campaign on YouTube, over 4 months in a seasonal ad campaign that would last merely 7 months, if not enjoined. In addition to other public
Mr. Panikowski, can I ask you about that? You talked about the timeline, and I'm interested, and we'll get to the merits, I guess, eventually. You already started down that road, but I'm interested in the argument from your colleague on the other side that because Nike only intended to have this campaign last for a finite amount of time, and that time has come and gone, that essentially this preliminary injunction is moot, and really what you all should be fussing about in front of the District Court is whether, if in fact you are interested in litigating the notion of a permanent injunction and or damages. But for our purposes, this preliminary injunction issue is not something that we need to rule on.
Your Honor, the appeal is not moot for 2 independent reasons. First, the PI prohibits more speech than just the SCE campaign and more speech than just the Sport Changes Everything tagline.
Okay, well, let me stop you there. So with respect to that, though, why isn't that an issue to be litigated on the question of whether or not a permanent injunction should be entered?
Your Honor, the reason why it's not merely an issue that can be punted to further District Court proceedings is because the preliminary injunction itself is drawn more broadly to any use, with certain exceptions, that is confusingly similar to
I understand that, but by definition, it's a preliminary injunction. So doesn't something else need to happen? Either it's dissolved, either it's converted into a permanent injunction. There's a trial, but I just don't understand why we're litigating something that your own client has suggested the focus of which was this campaign, which has ended.
Your Honor, it is correct that both parties agree that the focus of the preliminary injunction litigation was the campaign that has ended, but there are 2 reasons why this live controversy spans more broadly. First, the fact that the preliminary injunction was not merely limited to the SCE campaign, and therefore, because it prohibits any use confusingly similar to running Changes Everything or Change Everything, Nike is still subject to this speech restriction, where if Nike were to have some other campaign that used the word change, likewise in a non-infringing and fair use way, that Fleet Feet might seek to use the current preliminary injunction to go forward on that. The other reason—
I guess what I'm asking, Mr. Panowski, is are you suggesting that this preliminary injunction is going to remain in place forever? I mean, if we, doesn't this case contemplate some further proceedings?
Yes, Your Honor. The preliminary injunction, one way or the other, will not be in place forever. However, it remains in place right now and is restricting Nike's speech right now and potentially imposing a chilling effect on that speech beyond the confines of the SCE campaign. The other reason, Your Honor, even apart from that, why the appeal is not moot is because the preliminary injunction is secured with a $1 million bond. And the Supreme Court in the Grupo de Mexicano case made clear that in circumstances like these, the ability to recover on the preliminary injunction bond is something that by itself keeps the controversy alive and renders this appeal not moot. The Grupo de Mexicano case distinguished the case cited by Fleet Feet, University of Texas versus Kamenish, and limited it to circumstances where the PI no longer had any effect on the parties and the recovery on the injunction bond would merely duplicate an issue to be tried on the merits. Neither of those circumstances is present here, Your Honor. So even though the practical business import of the preliminary injunction dispute to the parties was Nike Sport Changes Everything campaign, and that's over, there is still a live controversy for those reasons.
Yeah, but counsel, we can't resolve that for you because the only thing here is appealing the grant of the preliminary injunction. If hypothetically, because we haven't decided anything, we're listening to your wise counsel, you and your good colleague. But if we determine that it is moot and we dissolve it, then you go back to the district court. You could still, I mean, theoretically, your client could lose on the merits. And even though the preliminary injunction may have been ill-advised on the merits, so we can't resolve those things you're talking about. But as to the effect of the preliminary injunction, once we dissolve it, it's over, no matter how broad it is. For the moment, then when you go back to determine the merits, which has not been determined, then they'll have to argue whether or not, in fact, it was confusing and parallel markers and all of those things that you wise counsel know in terms of dealing with trademark issues. So the two reasons you've given, I think they would be covered under mootness and dissolving the preliminary injunction. And as to your bond, you go back there, you post it in the district court. So that if you prevail on the merits, you say, look, I want my money. And that's the district court to determine that, not us.
Your Honor, it is true that if this court dissolves the preliminary injunction as the result of a mootness ruling, that our first reason for still having a live controversy would go away. If the court were to do that, it would be appropriate also to order the opinion accompanying the PI to be vacated, because otherwise Nike would not have had an opportunity for appellate judicial review of that opinion. However, Your Honor, it is not clear that if the PI were dissolved solely on the basis of mootness, that Nike would then have an opportunity to recover partial reimbursement for the premature arrest of its Sport Changes Everything campaign. Because unlike in the University of Texas case, where the money that secured the preliminary injunction bond was the same amount of money that was at issue on the merits, the $1 million PI bond that Fleet Feet posted is securing Nike against the injury that it already suffered from the premature termination of the SCE campaign. That amount is not directly in dispute on the merits. So it is not clear under Grupo de Mexicano and the University of Texas case that this court's dissolution of the PI for mootness would resolve the second reason why this controversy remains alive. Your Honor.
But again, I'm sorry to beat a dead horse, but why isn't that question then left to the district court?
Your Honor, is it the question of whether Nike can recover on the PI bond?
Right.
Your Honor, back at the district court in this scenario, Nike would argue that it should recover on the PI bond, but what we would be missing in that scenario is a ruling from this court that the PI was wrongfully entered. And that would be the basis on which Nike would be on the strongest footing to recover on the PI bond. Otherwise, the district court may be in a position of looking at what this court has done and saying that the PI was dissolved solely on the ground of mootness. Therefore, there hasn't been any determination that the PI was wrongfully entered. And the district court may, despite whatever arguments we may make at that stage, the district court may deny Nike recovery on the PI bond for that reason.
But it can
Or
only
it may not.
Yeah, it may, but you
Correct,
Or it
Your
may-
Honor.
I'm sorry.
it can only
That's correct.
do that if you lose on the merits.
Right.
If you lose on the merits, you shouldn't get it back. But if you do win on the merits, then the court would have no basis for not giving you relief on the posted bond. It all still hinges on what's left to be done by the district court, and that is the merits. And the merits, the money follows the merits, not this preliminary injunction one way or the other. For what our assignment is narrow. And we're saying we don't, that's one thing about Article 3, we have to have jurisdiction. We don't make advisory opinions when there's no matter in controversy. You have said by your own admission, the campaign is over, done with. So there's no need for, no matter how meritorious the grant or the PI was, or it was not, there's no need to keep it in place now. Therefore, it is dissolved upon the mootness. Now you go back to the district court to resolve both 1 and 2. I think 1 is resolved, but as to 2, at this point, I don't see how we could give you a judgment at this point that even if you won, that the injunction, and then you get the money back now at this point. Maybe we could. So I don't know. But it seems that the mootness is still a very viable question, and you've answered that. Unless you have something further, I know you have more to say, but or my dear colleagues want to ask you more. Go ahead.
Your Honor, I would simply like to add, setting aside the parties' arguments about the propriety of such an order in light of the Supreme Court precedent, if this court were to issue a decision that dissolved the PI in its entirety and vacated the accompanying opinion, and then specifically ruled and instructed the district court that Nike could recover on the PI bond if Nike were to prevail on the ultimate merits of the case. In that scenario, it does appear that the court would have addressed the 2 bases that we've asserted for a live controversy if the court were to make precisely that ruling.
I don't think that seems wrong to me on a couple of levels, right? Because you could well lose on the merits and lose money, and yet have been totally correct about the irreparable harm arguments that you're making, because those are limited to the injunctive relief. You could lose on the merits at trial and be forced to pay Fleet Feet damages, and yet the injunction that was issued be entirely inappropriate. So I don't think at all that the relief that's suggested would solve the problem that you've got. And it would have the additional problem that where you have the voluntary cessation of an advertising campaign, right, which is what Nike did, right? The injunction issues, like, they don't just stop doing it, they're ordered to stop doing it, right? And that we have this entire doctrine of the voluntary cessation, which requires that it be absolutely clear that you're never going to use any of those things again, any of the trademarks, in order for that to render it moot. I mean, it would be an odd world that you're acceding to the district court's order that you do something moots the very ability to appeal the district court's order that you not do it. I mean, that to me, the whole premise here of mootness strikes me as an odd one, because you're in a situation where you acceded to the district court's order and now are being told that because you've acceded to the order and stopped doing what you were doing, that you now can't appeal the order that you acceded to. That's contrary to the voluntary cessation doctrine that we see laid out in the host of Supreme Court cases.
Yes, Your Honor, we agree. And that is why Nike's position is that this appeal is not moot and there remains a live controversy. My response to the questions from your colleagues were premised on the scenario where the court decides to dissolve the PI based on mootness and outlining what conditions would need to be in that decision for that decision to possibly remedy the concerns that Nike has about having the PI and the opinion remain in place without the opportunity for immediate appellate review. So Nike's position, Your Honors, is that the case, the appeal, is not moot. However, if it is ruled moot, then Nike needs to be made as whole as it possibly can, which would mean at a minimum dissolving the PI, vacating the accompanying opinion, and ensuring that some opportunity is preserved for Nike to recover on the $1 million preliminary injunction bond at the appropriate time. And Your Honors, unless you have further questions on mootness or the merits, which I had begun to address, I will reserve the rest of my time for rebuttal, please.
Okay. Thank you, Counsel. Ms. Anderson.
Thank you, Your Honor. May it please the court. This is Corby Anderson, representing Fleet Feet Incorporated. I wanted to start with mootness, and because it is the threshold issue. And our point is that Nike conceded it has no plan to use sport changes everything in the future. And as told this court, it has no meaningful remedy from this court. Even if it won a victory on appeal, that would be a hollow victory because it chose to stop the sport changes everything campaign as of February.
No, but it'd get $1 million, right? I mean, that's what the Supreme Court in the, whatever it is, the Manahunt case says, is that the injunction bond alone, other arguments have problems too, but the injunction bond alone is sufficient to keep the controversy live. Why is that wrong? Why am I missing that?
The injunction bond doesn't save this appeal from mootness because Nike can recover on the bond if it prevails in the trial court. And Kamenisch has explained that in a case such as this, any issue preserved by an injunction bond can't be resolved on appeal and has to be resolved in a trial on the merits. Nike can't know if it will recover on the injunction bond until the propriety of its case on whether it wins the merits, because that's what determines recovery on the injunction bond. And Nike has, by declaring that it is ceased sport changes everything campaign and intends never to use it again and has no remedy here, Nike then is logically and under the law required to go back to the trial court where the case is currently stayed pending the resolution of this appeal. So the trial court
But that's what Grupo Mexicano says that doesn't work, right? So tell me why Grupo Mexicano doesn't apply here, not the Kamenisch argument.
Well, there are two reasons, Your Honor. One is that the underlying case in Grupo Mexicano, the underlying issue about the bond was an issue of whether the trial court had the authority to enter the preliminary injunction. The issue in Grupo Mexicano had nothing to do with the merits. This was a case on where an injunction had been entered to preserve assets. And so the issue in that case, the ultimate merits issue is money owed? But the question that was challenged in the preliminary injunction was, did the trial court have the authority to enter the injunction? And the second thing is that irreparable harm, which was the issue in, which was a question in Grupo Mexicano, would still have to be decided at trial. Nike has said the irreparable harm issue is another argument why this case is not moot. But that issue goes back to the trial court for determination. If this court, does what it did in Cincinnati, for example, and dismisses an appeal as moot and remands to the trial court, then Nike is free to ask the trial court to dissolve the injunction, and then the trial court can make a merits determination on whether Nike's entitled to recover on the bond.
But the two questions are separate. The point of Grupo Mexicano, as I understood it, was that the questions can be separated. And let's just imagine hypothetically that you develop new evidence that shows irreparable harm that you did not present to the district court for preliminary injunction. You might be able to use that new evidence to prevail in a permanent injunction, but it doesn't mean that the preliminary injunction was properly granted. And the injunctive bond, it seems, runs to whether the preliminary injunction was properly granted, because it's what really caused harm to Nike, stopping the ad campaign. A permanent injunction, right, which you may develop new evidence that you didn't present before that allows you to prevail, but that's still fundamentally different from whether the preliminary injunction was properly issued and whether Nike's entitled to the appeal bond.
Well,
bond, I'm sorry, I don't mean appeal bond.
I would direct the court to pages 314 and 315 of the Grupo Mexicano decision, because there the court explains that if the party who is in the position of Fleet Feet here prevails at trial, then even if it turned out that there wasn't adequate evidence of irreparable harm at the time, that would be harmless error, because ultimately when the merits are decided, then that would mean there was the irreparable harm preliminary finding didn't matter. So I think Grupo Mexicano.
That was true in Grupo Mexicano, but not true here, because Nike only really cared about the 5 months that you shut down, right? They don't care about 2023 right now. Like, what they cared about was the untold millions of dollars that they had spent on this ad that you stopped, right? Not the future, right? What they cared about was the preliminary injunctive piece. I mean, that's the real harm to them. So that may have been true there, but it doesn't seem as true here.
But Nike voluntarily ceased this conduct and has in effect ensured that this appeal is moot.
You mean Nike voluntarily ceased after the district court ordered them to do so? That's not typically what we call voluntary cessation, right? Like, we talk about voluntary cessation when they stopped doing the running changes everything. That was voluntary, right? But the rest of it, the sport changes everything, is only after there's an injunctive order from a federal judge saying stop. That's not voluntary, is it?
Well, there's no reason that Nike couldn't resume the campaign. That's their choice, not to resume the campaign.
They can't today without violating a federal order.
Right, and that's why that's why the trial court, rather than this court, should resolve that issue, because they have chosen to stop the campaign, and that requires this case to go back to the trial court. And they have that remedy in the trial court.
Is that true for any preliminary injunction? So if you comply with a preliminary injunction, then it necessarily moots the appeal on your theory, because you're not doing what the district court ordered you not to do. That theory seems to swallow the rule. We would never have an appeal of a preliminary injunction unless somebody's under contempt of court for violating the federal order.
Your Honor, after Nike has said it can have no meaningful remedy from this court, that seems like a concession that Nike needs to go back to the trial court for its remedy. And the trial court would, it's there that the issue of whether the injunction should have been granted would be decided. Nike could try this case, prevail on the merits, and get the bond back, presumably, or recover on the bond, I should have said. But by declaring that it had no meaningful remedy from this court, that deprives this court, and the fact that there's no case or controversy, that should deprive this court of subject matter jurisdiction. So it's not that Nike has no forum for resolving these disputes, it's that the proper forum is the trial court. Unless there are other questions on this, I'll go ahead to the merits. There are two issues that recur throughout this appeal: the clear error standard of review and reverse confusion, and both call for affirming the trial court. The findings that Nike challenges on likelihood of confusion and fair use and irreparable harm are reviewed for clear error. And the trial court made those findings after considering more than 1,000 pages of evidence, 3 hours of argument from counsel. It issued a carefully worded 51-page opinion, and its findings in that opinion are correct, but they need only be plausible for this court to affirm them. The trial court's findings easily satisfy this standard. Now, the trial court correctly recognized this is a reverse confusion case, and there's nothing novel about reverse confusion. All 10 federal circuits that have considered it have adopted it. Trial courts within this circuit have applied it, and the restatement of unfair competition has endorsed it. And the trial court recognized that this case has all the earmarks of reverse confusion, and properly judged the case under the reverse confusion standards rather than forward confusion standards. Nike contends that the trial court's errors are that it applied these reverse confusion standards. In fact, what Nike wants is the application of forward confusion standards that don't fit this case, and the court should reject that argument. On likelihood of confusion, I'll touch on that just briefly. 3 of the 8 factors that the trial court considered Nike has assigned error to: similarity of the marks, intent, and actual confusion. On similarity of the marks, the trial court used this court standard in Pizzeria Uno, and it measures similarity by the distinctive portion of the mark. So in that case, Pizzeria Uno and Taco Uno were considered confusingly similar because the distinctive part, Uno, was identical. You can't just switch out taco for pizza, for pizzeria. That doesn't make them dissimilar. Here, the trial court found that running changes everything and sport changes everything were confusingly similar for the same reason. You can't just sub out sport for running and make the marks dissimilar. And the common element changes everything is the entire mark for Fleet Feet's change everything. Nike, and this is one of those cases where the reverse confusion versus forward confusion standard comes into play. Nike argues that using its house marks, the word Nike and the swoosh negates similarity, but in reverse confusion cases, the vast majority of courts have held that it actually exacerbates confusion because it reinforces the association of both parties' marks with the junior user. So the trial court correctly found that this factor weighs decidedly in favor of Fleet Feet. On the intent factor, Nike faulted the trial court for failing to identify one iota of evidence that Nike intended to excuse me, confuse consumers, but intent to confuse is the forward confusion standard. For reverse confusion, courts look at whether the junior user knew about the senior user's mark. The trial court found that Nike did know when it adopted Sport Changes Everything, and it cited compelling evidence. And I'll just cite a few of the pieces of evidence. That Nike and Fleet Feet had a long-standing relationship as competitors and business partners, and a Nike brand manager worked from Fleet Feet's headquarters in Carborough, and a mural of Running Changes Everything covered the wall right outside his office door. That appears at page 300 of the joint appendix. Nike faulted the trial court for making an inference that it ran a search for other uses of similar marks, which would have revealed Fleet Feet marks. It was reasonable to infer that a company as sophisticated as Nike, as experienced in trademark litigation as Nike, would follow this standard practice before launching a multi-million-dollar ad campaign. But if there were any room for doubt about that inference, Nike eliminated it when it argued in its fair use defense, and this is at page 32 of its initial brief, that it selected Sport Changes Everything in light of the widespread use of similar terms. How could Nike have known about this widespread use of similar terms without searching for them? And how could a search not have revealed running?
Well, but can you have, that doesn't seem right. Can you well have a term that's in common everyday usage, right? Take, for example, sealed with a kiss, right? Which we see coming up in a variety of contexts. I got daughters, right? SWIK like shows up all over my house. But I've done no trademark searches to know whether it's trademarked or not. Right? Nike's just saying something changes everything is a common vernacular term, not a trademark term, right? Those seem to me totally different ideas.
It would be the standard practice to run a trademark search and then winnow that search down to the uses that are in your same field, because those are the ones that matter. If you
But your point was a different one. Your point is they conceded that they did something because they said something changes everything is common vernacular. But I agree with them on that, but I don't see how that goes to whether they did a trademark search or not. Like, I think it's a common term, but that doesn't mean that I did any trademark searches. I'm not sure I'm following the logic of what you're saying, is what I'm trying to get at.
Your Honor, my point is that to say you acted in good faith because of the widespread use of similar terms, that there's certainly an implication there, to me, an inescapable implication that you searched to determine that. You can have a hunch about something, but would you bet $16 million on it if you hadn't? Wouldn't you want to be more definitive than that?
Why wouldn't the inverse, Ms. Anderson, the inverse of that be equally damning? That is, that a company as sophisticated as Nike that fails to conduct a search, necessarily needs to accept the consequences of that failure.
Well, it certainly should accept the consequences of that failure. And
I mean, the argument could be, well, it just doesn't want to know. It's going to go forward and do what it wants to do and blind itself to the reality that there might be a possible trademark issue, and we're just not going to look. We're not going to be concerned about that. And why isn't that equally problematic?
It is problematic, and it goes back to the intent factor, which also the intent factor is whether a company knew or recklessly disregarded. And if the rule were that you could just recklessly disregard marks that are confusingly similar to the one you want, you should pay. You should pay a toll for that. I mean, that would be a terrible rule, is what I'm saying.
Can I ask you a question about this issue of actual confusion? I understood from the record that there were apparently a number of views of this campaign, I believe 18 million or so, and there's no evidence in the record that I can see that there was any actual confusion. So isn't that, I mean, doesn't that sort of cut against a finding of a likelihood of confusion?
Your Honor, it does not. It has to be, first of all, the trial court ruled that this factor favored Nike in its analysis, but trial courts don't require actual confusion to prove likelihood of confusion, and there's a good reason for that. It is that like evidence of actual confusion is incredibly hard to find, and it's judged over the length of time that it's been out there. So this campaign has been out there for only a few months. No discovery. It's completely unremarkable that the confusion wouldn't have surfaced by this time, and that's why courts don't require actual confusion. And to do so would mean that you would have to be harmed. There'd be concrete evidence of your harm before you even seek relief for it, can seek relief for it. I see that I am past my time. I'd like to, if the court would indulge me, just point out a few pages in the joint appendix that I'd like the court to look at. It's a 2,000 plus page appendix, and these pages I think, illustrate the use of sport changes everything as a mark, which is a critical issue. May I just cite these pages?
Yes, Counsel.
To the court? Thank you. They are 1465 and 1460, showing how sport changes everything is used as an attention-getting symbol, and as Nike used Just Do It. Then 165 and 1668, showing the use of the mark in product displays in stores in exactly the same way that Fleet Feet uses Running Changes Everything. 455, 1468, and 318, showing use on social media. And finally, 333, which shows Nike-sponsored athletes using Running Changes Everything, Fleet Feet's exact mark, to invite consumers to visit them at Nike's online store. And to give a full picture, when Fleet Feet complained of that, Nike changed running to sport, but that just shows how similar these marks actually are. Thank you for letting me cite those pages.
Thank you, Ms. Anderson.
Certainly.
Malakowski, you have some time reserved.
Thank you, Your Honor. Your Honors, the district court's irreparable harm and reverse confusion rulings fall apart when viewed through the prism of the particular theory of reverse confusion that the district court incorrectly embraced here. This wasn't the more typical type of reverse confusion case where one might encounter Nike's marks and then Fleet Feet's products and think that Fleet Feet's products come from Nike. Rather, it was something very different. What the district court said at page 2014 of the joint appendix is that consumers would encounter Nike's Sport Changes Everything campaign and then reasonably carry those ideas with them into a Fleet Feet store, where upon seeing Change Everything and Running Changes Everything, the district court said consumers may assume that or wonder if Nike owns or controls Fleet Feet. Your Honors, that is not a reasonable assumption, and certainly not one that can support the preliminary injunction here. What the district court is supposing is that someone, because they saw the Nike Sport Changes Everything campaign, would then walk into a Fleet Feet store, see all of these different brands, some of Nike's fiercest competitors in the running space, see Under Armour, New Balance, Asics, and more of the 25 brand partners that Fleet Feet itself lists on its website at pages 194 and 195 of the Joint Appendix. And the district court speculated that that consumer would walk into that store or visit Fleet Feet's website and see all of these different competitive brands and think to themselves, oh my gosh, did Nike acquire Fleet Feet? That is not a reasonable assumption, Your Honor. Yet that was the entire basis for the district court's reverse confusion ruling and its irreparable harm ruling, and is one of the reasons why those rulings should be vacated. The remaining time in the campaign is also very significant here. By the time of the preliminary injunction hearing, the campaign had been underway for 4 months, and there were 3 months left. The district court itself found that Nike's use of the sport changes everything advertising slogan was widespread, and that because of that, and because of Nike's pervasive presence online and in social media, the lack of any indication of confusion calls its existence into question. So the district court was basically saying, even though this may only be 4 months, those 4 months are like dog years here, given the extent of Nike's use. And then you compare that to the fact that only 3 months remained in the campaign at that time. And this court's decision in Direx Israel requires that before a PI is entered, something that this court called an extraordinary and far-reaching remedy that should only be issued in limited circumstances where it's clearly appropriate, that harm cannot merely be remote and speculative. It has to be actual and imminent. As the court said in Direx Israel, there has to be some immediate harm that would occur absent entry of a PI. If in the first 4 months of the campaign, with a commercial at the Major League Baseball All-Star Game on TV, a commercial at the ESPY Awards on national TV, over 18 million YouTube views, as the district court itself found, other extensive uses online and on large public billboards. If those 4 months had not produced any indication of confusion, we're using the district court's own findings here. That's why we're not concerned if this court applies the clear error standard, because many of the district court's factual findings favor Nike. The district court just drew the wrong legal inferences from those findings. If that were the case over the first 4 months of the campaign, and then Fleet Feet couldn't produce a single consumer, a single franchisee, a single employee, a single anyone who was confused, and also could not produce a declaration from any one of its 153 franchisees, or based on consumers coming to the doors of any of its 182 stores total, or seeing Fleet Feet online. And amidst that entire sea of potential evidence and exposure to Nike's campaign, the fact that Fleet Feet was unable to produce any evidence of actual and imminent irreparable harm absent a preliminary injunction by itself renders the district court's irreparable harm ruling legally erroneous. And Your Honors, I see my time has expired. May I please address 2 more points briefly from this court's case law?
Ms. Pentecost, may I just ask you a very quick question?
Yes, Your Honor.
If we agree with you and rule with you on all of those aspects of the findings that relates to preliminary injunction, hypothetically, we did. Are you saying that would be preclusive if, when the case goes back on the merits, that Fleet couldn't come back with a full record on the merits and prove those elements? Would it be dispositive of that?
Your Honor, whether it's dispositive would depend on the precise scope of this court's decision and mandate in the appeal. But in general, the fact that a party was unable to secure a PI at a particular time does not necessarily mean that it won't be able to show that it's met the elements for a PI at a later point in time.
Exactly, right. So it goes back either way on the merits.
Your Honor, that is correct. Yet by reversing the decision here and vacating the PI, the district court also will receive important guidance for the merits. And two important points in this court's case law that the district court did not follow are, one, from the Care First decision of this court at page 267. This court said, although proof of actual confusion is not necessary to show a likelihood of confusion, the absence of any evidence of actual confusion over a substantial period of time creates a strong inference that there is no likelihood of confusion. And 4 months of an extensive campaign relative to the 7-month seasonal duration is in these circumstances a substantial period of time. Also, this court in George and Company at page 398 said that the failure to conduct a trademark search or contact counsel, something that the district court inferred here based on speculation, this court said that that shows carelessness at most, but is in any event irrelevant because knowledge of another's goods is not the same as an intent to mislead and cause consumer confusion. The intent required for both forward and reverse confusion has to be the intent to confuse consumers, because that is the only harm against which the Lanham Act protects. The Lanham Act does not create two different sets of standards for forward and reverse confusion. And therefore, the same standards that this court applies in a forward confusion case should also apply to reverse confusion. Otherwise, it would transform reverse confusion into a mutant species of trademark law, where weak marks would be giving special protection and preferential rules precisely because they are weak. This, Your Honors, would turn trademark law on its head. Therefore, Your Honors, the court should rule that the district court erred either as a matter of law or in clearly erroneous ultimate findings of fact, vacate the preliminary injunction, and remand the case to proceed on the merits. Thank you, Your Honors.
Thank you, counsel. Thank you both for your arguments. Please know that we appreciate your arguments, even though we don't shake your hand. But thank you so much. And this and many other cases are difficult, and good lawyers like yourselves coming here to help us on these are very much appreciated. We wish you well, be safe, and stay well. And we'll ask the clerk of the court to adjourn for today.
Thank you.
This honorable court stands adjourned until tomorrow. God save the United States and this honorable court.